Your first and last names are on the calendar, first and last name, so that I can identify you and which case you are connected to. All right. So December 11th, 2025, the first case on the 10 a.m. calendar is Frankie Bailey. Lawrence Korn is the attorney. Frankie Bailey.
Your Honor, when I spoke with that attorney, he said he was not going forward on that.
Okay. Did he file a withdrawal?
I have not checked with.
All right.
Haven't seen a withdrawal, Judge. Haven't received and or heard from him.
All right. Well, that motion is withdrawn. Anyone here on behalf of Frankie Bailey, you're free to go at this time. Next is Junior Campbell. Junior Campbell. Jonathan Ross is the attorney. Junior Campbell. I have that Mr. Campbell filed a motion to withdraw as counsel. And that the notice in this case was returned.
It appears that Attorney Walsh was the attorney, and then he withdrawn, and then Jonathan Ross was appointed.
Okay, I don't have either of them here.
Right, either not here, but.
Is Mr. Campbell present? All right, motion will be dismissed for want of prosecution. It'll be on the February 2nd trial calendar. Aurora Colon, this case is closed, and that's a motion to seal. Ms. Colon, is there anyone representing Ms. Colon, or is Ms. Colon representing herself?
Judge, she's present in the courtroom.
Come on up.
Come up to the podium.
Any objections from the state?
No, Your Honor.
All right.
Stand right there in front of the sheet. That's the microphone.
All right, so Ms. Colon, these look like matters that can be sealed. We'll review the petition, and then we'll get you out in order, okay?
All right, thank you.
All right, thank you, ma'am. So understand that sealing the court's records, the paper records is quick and easy. Sealing the digital records may take a minute because they have to deal with IT, but it'll happen.
All right, thank you very much.
All right. You're welcome, ma'am. All right, Christopher Jade Foreman. Christo Upshaw is the attorney.
He's present.
All right, come forward.
Your Honor, Kyle Gifford on behalf of Mr. Upshaw. He's dealing with a matter in Spalding County this morning. This was placed on a motions calendar. We submitted our typical packet of motions. None of them were particularized. So we're not going forward on any motions this morning.
All right, are you talking to the state about a possible resolution, or are you going on a trial calendar?
Mr. Upshaw has spoken with ASG Bing about a reduction. We'd like to continue talking, but
okay,
perfectly fine setting it down for a January or February trial date.
All right, the motion is withdrawn. You'll get your trial notice. All right, Kyle Matthew Gully.
That's going to be a negotiated plea today.
All right, Mr. Gully, raise your right hand for me. Do you solemnly swear or affirm any testimony you give in this matter will be true? You got to speak up for me, sir.
Yes, Your Honor.
All right, you can put your hand down. So you're before the court on State of Georgia versus Kyle Matthew Gully, 2022 CR 05691, DUI count 1, DUI less safe count 2, following too close count 3. Your motion is withdrawn, but you are entering into a plea. Mr. Lynch, from the law firm of Lister Holton Dennis, what is your client plea to the offenses before the court?
Judge, it's going to be a guilty plea to count 1, count 2 merges. It's plea to count 3.
I'm sorry?
No contest to count 3.
All right. So, sir, by entering a plea of guilty to count 1, count 2 will merge. Count 3 is a NOLO plea. You give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf tonight.
Hey,
And
Judge,
if you are, I'm sorry.
I'm sorry, I just wanted to put you on notice that we weren't hearing those last comments you were making when you kind of got away from the microphone. It kind of
Right.
got silent.
So by entering a plea of guilty or nolo, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony or evidence on your behalf, to not incriminate yourself. And if you are not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things?
Yes, Your Honor.
Recording in progress.
All right. Someone has two devices on and you're not muted, please your device if I'm not speaking to you. All right, so factual basis recommendation, please.
September 23rd, 2022, officers observed a car running without anyone in it. When they were running the license plate, they observed the defendant walking from an apartment complex, barefoot, unsteady, unbalanced, stumbling, and approaching the vehicle. When officer approached, he detected a strong odor of alcoholic beverage coming from the defendant, observed red and glossy eyes, asked if he had been drinking. He said yes, about an hour prior, about 4 to 5 bottles of Busch beer. He did agree to do standardized testing. Standardized field sobriety testing. Officers assessed 6 out of 6 for HGN. 5 out of 8 for walk and turn, and 3 out of 4 for one leg stand. The state's recommendation for count 1 is, this is his first in life, or first in 5 rather, 12 months to serve 1 day, credit for time served, balance probated, a DUI risk reduction program, no drugs or alcohol, random screens, 40 hours of community service, and substance abuse evaluation and any recommended treatment. Count 2 would merge with count 1.
No fee, no fines and fees.
There is a $300 fine, yes. For count 3, it was just an $85 fine.
All right, so mention anything on behalf of Mr. Gully?
No, Judge, I believe this is his first in life, and he has obviously had no further infractions of this sort since the time he's moved on with his life. We're asking the court to accept the plea as negotiated.
All right, Mr. Gully, hopefully this is a learning experience for you. If you're sitting at home drinking, it would never come to my attention. That's between you. But when you get behind the wheel of a car with too much alcohol or any illegal substance in your system that alters your ability to respond, you could put your life and somebody else's life at risk. And there is no punishment that anybody could give you that would be the same as waking up every morning knowing you killed someone or you caused some catastrophic injury. You understand? So
Your Honor.
please be mindful of that. I'm going to accept your plea of guilty to count 1, nolo to count 3. Count 2 will merge into count 1. I'll sentence you on count 1 to 12 months to serve 1 day, credit for time served, balance will be probated. You'll take a risk reduction course. You'll do a substance abuse evaluation and any treatment that they may order. You'll pay a fine in the amount of $300. The surcharges on that fine are going to be pretty high. So expect something in the, it may be less, it may be more. 40 hours of community service. And count 3 will run concurrent with count 1. It's an $85 fine. The surcharges are going to make it somewhere in the $100, $150 range. Okay. I'm going to put you in a breakout room with our probation expert. She's going to take all of your information. She can answer any questions that you might have. Please, if you have questions, ask those questions to make sure that you successfully complete probation. Are not communicating with your probation officers, you will not get through this successfully, because they will go to bat for you if you have any trouble. But you gotta show up for probation reports. The quickest way to get rearrested is to fail to show up. And the second thing is you have got to make sure you communicate with them. Okay, do you understand all of these things?
Yes, Your Honor.
All right, so Mr. Gully, I'm going to put you in breakout room number 6. Ms. Nailbot, it's going to be in breakout room number 6, and she's going to speak with you and do your intake, okay?
Thank you, Your Honor.
All right. You'll see the invitation pop up in a moment. 6. There you go. All right, you do not have to come back to the main room. Just make sure that you do what's necessary for probation. Next on the calendar, Marquise Lamont Johnson.
Your Honor,
Mr. Dennis, yes.
yes, Your Honor. Attorney Tortorello on behalf of Mr. Marquise Johnson. He's on the Zoom call. We're moving forward with the hearing today.
All right. Next is Rodriguez Revolto Maddox. My understanding is but the state has spoken with Mr. Overman and the motion has been withdrawn. Is that correct? Ms. Bing?
Yeah, can you hear me?
I hear you now.
Yes, Your Honor.
All right.
That's true.
Next is Jalen Martin.
Judge,
Mr. Holden Dennis.
Mr. Martin is present in the courtroom, Judge. I did file a withdrawal of the motion. I'm not sure if y'all got that. That was filed yesterday. Judge, I would just note that the state did drop additional discovery on us yesterday at 5, which did include some potential references to his medical records. So I haven't had time to really review that, but I likely will go forward on a motion in limine with regard to some of the items that we received yesterday.
All right, so trial will likely be in January or February. Okay,
is Mr. Martin excused for today?
Yes. Chloe Angelique Mason.
Your Honor, Ms. Mason is present. We will be moving forward with a negotiated plea today.
All right, Ms. Mason, raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true.
Yes, Your Honor.
All right, you can put your hand down. All right, so for those who are asking, Ms. Mason, thank you for your patience. Hold on a second. Anybody, when I say the motion has been withdrawn, witness, you belong to the state or the defense. So for my purposes, if I say motion is withdrawn, I don't need you anymore. But please make sure you check with whoever sent you the subpoena to make sure it's okay for you to leave. But for me, yeah, motion is withdrawn. Then if you don't have anything else, you're free to go. All right. Ms. Mason, you're before the court for case 2022 CR 06243, DUI, count 1, DUI less safe, count 2. You're represented by Attorney Lynch with the law firm of Lister, Holton, Dennis. What does your client plead to the offenses before the court, Mr. Lynch?
Your Honor, yes, Your Honor. Attorney Tortorello for the
I'm sorry, Ms. Tortorello.
That's fine. No worries. For a DUI, that will be a guilty plea, and then count 2, DUI less safe, will merge into count 1.
All right. So Ms. Mason, by entering a plea of guilty to count 1, count 2 will merge. You you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself, and if you are not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things?
Yes, Your Honor.
All right, factual basis recommendation, please.
On May 15th, 2022, officers made contact with Ms. Mason during an investigation. They observed that she was in actual physical control of her GMC terrain. While checking her driver's license status, officers observed the smell of alcoholic beverage, dilated pupils, and glossy eyes. She had advised that she had been drinking prior to driving. SFSTs were conducted, and did submit to a blood test where her blood alcohol level was 0.14. The recommendation is 12 months to serve 1 day. I have to see if that credit would, if she's already served that. But 12 months to serve 1 day, $300 fine, 40 hours of community service, substance abuse evaluation and any recommended treatment, risk reduction program, no drugs or alcohol, random screens.
All right. Ms. Tortorello, anything on behalf of Ms. Mason?
Only that you accept the plea as negotiated, Your Honor.
All right, Ms. Mason, you heard me tell the other gentleman that there's nothing I can sense you to that would make up for the fact that you hurt someone or killed someone by reckless actions. I understand that this was a couple of years ago, but please make sure that we don't do that anymore. I don't understand why I'm still doing DUI cases, because y'all have stuff that we didn't have. We couldn't call Lyft or Uber or any of those. We had to call our parents or a family member, and we were going to get talked about like a dog, which a lot of people would not call because of that. But now y'all can pay $30 and be where you want to be and get home safe, and everybody else gets home safe. But I don't understand why I'm still doing DUIs. I don't understand why that's still a part of my job. But people just don't learn. Plus, the Lyft service, I'm not invested in them in any way. I don't make any money from them. But I'm gonna tell you, pay that is a lot cheaper than what you're gonna end up doing on a DUI. Just FYI and public service announcement. All right, so ma'am, I'm going to accept your plea, 12 months, 1 day, credit for time served, balance will be pro for you to pay a fine in the amount of $300, look to it to be about $700, 40 hours of community service, a substance abuse evaluation and any treatment that might be ordered, a risk reduction course, no alcohol or illicit drugs during the course of your probation, and you're subject to random screens. Please make sure you report for your probation reports, because failure to report is the quickest way to get arrested. I will get an arrest warrant request and I will sign it. So please make sure you report. Please make sure that you do what is necessary. And if you have any difficulties completing anything for probation, make sure you speak with your probation officers. They will go to bat for you if you're doing what you need to do. Okay. So please
Yes,
make
ma'am.
sure that you do that. The Ms. Nalbon is in with Mr. Gully. If you hold on a second, I'm gonna put you in a breakout room as soon as as she's clear. Okay. So
Yes, Your Honor.
no problem.
I'm sorry. Miss Mason, she served 2 days. I want to give her credit for both of those days.
Oh, all right. I'll give you 2 days credit for time served. All right, so just hold on, Miss Mason, mute your device. You'll see when I get ready to put you in there, I might not be able to tell you it's coming, but you'll see an invitation to the breakout room pop up, okay? I might be talking to someone else at the time. All
Yes,
righty,
Your Honor.
thank you. All right. Next on the calendar is Brandon Samuel McKinney, Lister Holton Dennis.
Judge, Mr. McKinney is present in the courtroom. He's handed me his filled out application for DUI court. My understanding is that this is the state's motion to revoke bond, but I believe that we have an agreement that the state would not go forward on the motion today, provided that he submits his application and goes forward with a DUI court plea resolving his cases at the first opportunity, if Ms. Bing would like to add anything.
No, that's correct.
How many DUI arrests is it?
Judge, he has 2 DUI cases pending before your honor.
Come, Mr. McKinney, come here, sir. Ms. McKinney, who you trying to kill?
No one at all.
No, sir, you have to be, because like I just said, they got Lyft, they got Uber, they got all of these things. You could pay your cousin to drive you around, but you got 2 cases before me. Who you trying to kill? Because really, you better hope you get into DUI court, because you sure enough, if you get convicted of them 2 cases before me, you're gonna be in the Clayton County Jail. That's not an experience you want right now. Go on YouTube and see what's happening up in there. So what I'm saying to you is, get a clue. Why are you risking your life and everybody else's? And really, I don't care about your life, because you don't care about it. If you're willing to get out here and DUI your way through life, you don't care about your life, but that's on you. Don't try and kill somebody else, because you would be the one to survive a catastrophic collision, but somebody's baby would die, or somebody pregnant, which we've had happen twice in the last 4 to 5 years here in Clayton County. Or you would kill a mama who coming home from work trying to get to her babies. Get a clue, sir. And let me tell you another thing. You're an alcoholic. I know you don't want to admit it, which is why you keep drinking and driving, but you're an alcoholic. And let me tell you how I understand alcoholism. When you end up before a judge for DUIs back to back, when you are in jail for something that you wouldn't want to be in jail for, nobody wants to be in jail, but you're going to jail for alcohol. When you're losing time on your job for alcohol, you're going to pay lots of money for alcohol. You're an alcoholic, sir. And the quicker you acknowledge it and embrace the fact that you're an alcoholic, the quicker you're going to stop putting other people's lives.
Yes, ma'am.
Do you hear me?
Yes, ma'am.
Because I don't think you hear me though.
I do.
Because you got 2 DUIs, you got a DUI, like literally Miss Bing is being very generous. Because I really feel like Christmas coming up, you're going to be out here with your boys. They're going to be trying to console you, man, it ain't that bad, take a drink. And you're going to end up drinking. I tell you what, this is what we're going to do. You're going to have a modification of your bond that's going to say that you're going to come in randomly for tests. You have no alcohol or illicit drugs during the course of your bond period until such time as your cases are resolved. So you will not be able to drink. If you test positive for alcohol or illicit drugs during the course of your bond until your cases are resolved, then you're going to come see me.
Judge,
and I guarantee you're going to be in the Clayton County Jail. So if you want to spend Christmas there, really play with me. If you want to spend New Year's there, really play with me. Because I would rather have you in the jail than on the street. You feel me?
Yes, ma'am, I do.
Because I was fully embracing the fact that I was getting ready to hear a bond revocation for you. Because let me just let you in on another little thing. Had a guy came in, got a DUI around this time of year. Well, he felt like I wasn't really talking to him. He goes out and kills a 19-year-old girl on her way home from work right before Christmas. She was probably on her way home from work to go Christmas shopping. That's how close it was to Christmas. He hit her at 85 miles an hour and did not slow down. That's what the computer said. That's how fast he was going when he hit her. He got a broken leg. She died. So you're an alcoholic. Say it with me. I am an alcoholic.
I'm an alcoholic.
Say, my name is Brandon McKinney, and I'm an alcoholic.
My name is Brandon McKinney and I'm an alcoholic.
Okay. I need you to say that to yourself and embrace it. Because as long as you deny it, you're going to put people's lives at risk. All right. Mr. Lynch, get me that bond modification drawn up and I'll sign it so that if he drinks or if he doesn't come in for a random test, he's going to the Clayton County Jail.
Judge, I can get that to you shortly.
Thank you. All right,
Judge.
Mr. McKinney. Hopefully they'll take you in DUI court because I think that judge is nicer than me. Have a seat.
Judge,
Yes.
it appears that Marcina Davis, AI assistant, is recording. I don't know, she may need to sign back off and turn that off because it's still recording. It's coming up to me saying it's recording. And it's appearing to the court reporter also. So Marcina Davis,
Yeah, I
It's
don't
a-
know why she's recording us.
right.
Ma'am, I'm clear. It's an AI that automatically does it. I have to figure out how to turn it off.
Well,
You may
sign
have to
out
sign off.
Sign out and come back in.
Yes, ma'am.
All right. Next is Marquise Roland Mitchell. Marquise
Honor.
Roland Mitchell.
Yes, he's on the Zoom, Your Honor. We're ready to move forward with a negotiated plea.
All right, Mr. Mitchell, raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true.
Yes, Your Honor.
All right, you can put your hand down. So, Mr. Mitchell, you're before the court on 2022 CR 01773 for DUI less safe, count 1. Suspended registration, count 2. No tag expired or invalid tag, count 3. No insurance, count 4. Improper lane change. Was anything right about your car? Improper lane change. Miss Tortorella, what is your client pleading to counts 1, 2, 3, 4, and 5?
Your Honor, for count 1, DUI less safe, that will be a guilty plea. My understanding is count 2 and count 3 will be no prost.
PK, Robin.
All right.
Count 4, no insurance is a no-low plea. And count 5, improper lane change, that's a no-low.
All right. By entering a plea of guilty to count 1, counts 2 and 3 will be no pros. Count 4 and 5 will be no lows. You give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself. And if you are not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things?
Yes, Your Honor.
All right. Factual basis recommendation, please.
On February 18th, 2022, officers responded to an incident location in reference to a single vehicle accident. When officers made contact with the fire already there, they advised that they could smell the odor of alcoholic beverage. The officer did confirm that when he made contact with the driver. He noticed that he was unsteady on his feet, had puffy eyes, was swaying and moving back and forth. He also observed in the vehicle that there were a few cups of something in the vehicle that smelled like an alcoholic beverage. The driver did submit to standardized field sobriety tests. However, he was only able to get through HGN. He did see 6 out of 6 for HGN. The driver became belligerent, so the officer did not continue. He did agree he was read implied consent and did agree to take a blood test in which the blood alcohol content was 0.186. The state's recommendation for the DUI count is 12 months to serve 48 hours, $500 fine, balance probated, substance abuse evaluation, random testing, no drugs or alcohol, risk reduction course, and 60 hours of community service. No tag or suspended registration or null prost. No insurance is a $200 fine. And improper lane change is $100. Yeah, it's $100 fine.
Counts 4 and 5 will run concurrent with count 1.
Yes.
Count 1 is 12 months, 48 hours, credit for time served. Balance will be probated for you to pay a fine in the amount of $500, a substance abuse evaluation, and any treatment that may be necessary. No alcohol or illicit drugs during the course of your probation. You're subject to random screens for alcohol and drugs, a risk reduction course, and you'll do 60 hours of community service. The $500 fine is going to be enhanced fines and enhanced fees because of the DUI. So it's going to be pretty hefty. It's going to be over $1,000, I think. So be prepared for that. Count 4 is a $200 fine, which is going to be $298. Count 5 is a $100 fine, which is going to be $151.50. And your DUI, the sentence on your DUI tells me that this ain't your first rodeo. Just as I've said to other people, if DUI is landing you in, if alcohol is landing you before a judge multiple times, sir, then you're an alcoholic. You need to embrace that.
Yes, ma'am. And I've definitely embraced that, which has led me to just be sober altogether these last couple of years. I had to come to that realization myself.
Good, because it seems to be that I'm the bearer of bad news. By the time people get to me, I got to tell them they're an alcoholic, even though they've got multiple DUIs, they don't seem to get it. I'm glad you get it. What I would suggest is that you understand that alcoholism is a disease like any other. If you fail to treat hypertension, you'll die. If you fail to treat diabetes, you'll die. So if you fail to treat alcoholism, you might die, but you might kill somebody else.
Yes, ma'am.
Be in treatment. Go to meetings, make sure that you check in with people, get a sponsor so that you can live a good, sober life and not put anybody else's life in danger. I'm going to put you in a breakout room with the probation expert. The quickest way to get rearrested is to not appear for probation. So please be mindful that you have to appear for probation. You also, Ms. Nalban, Ms. Mason is in the breakout room. You also have to, if you have any difficulties, please make sure that you speak with your probation officers and tell them that you're having difficulties completing something. Because if you don't, then you will mess up your probation and you'll be the only person responsible for it. So you got me?
Yes, ma'am.
All right. All right. So Ms. Nalban is going to be in the breakout room with Ms. Mason. So, and I'll put you in a breakout room with her as soon as she is able to take you, okay?
Yes, ma'am. Thank you.
All right. Just mute your device, sir. You'll see the invitation pop up when I'm ready to put you in the breakout room. All right, next is Devontae Damon Ogletree. Ogletree.
Your Honor, Mr. Ogletree is present plea today.
Mr. Ogletree.
Yes, ma'am.
All right, let me find you. I hear you. I don't see you. All right, raise your right hand for me, sir. You solemnly swear or affirm any testimony you give in this matter will be true.
Yes, ma'am.
All right, you can put your hand down. So you're before the court on 2022 CR 06250 for DUI, DUI less safe, and speeding. You're represented by the law firm of Lister, Holt, and Dennis. This is you, Mr. Lynch, right?
Yes, Your Honor.
All right, Mr. Lynch is with you. Mr. Lynch, what is your client plead to the offenses before the court?
Judge, I know it's a guilty plea to count 1. Count 2 would merge. And Ms. Binkin, I think it was we just discussed the plea to count one, is that correct? And the no process count three, or was that not contemplated?
I don't think that we did discuss count three.
Yeah.
It was just going to be $100 fine, but we can suspend the fine.
Okay, so that'll be a guilty plea to count three as well.
All right. So Mr. Ogletree, by entering a plea of guilty to counts 1 and 3, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself. And if you are not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things?
Yes, ma'am.
All right. Factual basis recommendation, please.
Yes, on May 7th, 2022, officers observed a car speeding 68 and a 45. When they made contact, they found that the license was suspended and the driver's speech was slurred. They could also smell the odor of alcoholic beverage. When they asked him if he had been drinking, he said that yes, he had been drinking 2 shots of Crown Royal whiskey, 3 cups of margaritas. He did agree to field sobriety. And the PBT showed that he tested positive for alcohol. He did also agree to a sample of his blood, and that came back at a 0.082. The state is recommending 12 months to serve 1 day credit for time served, $300 fine, 40 hours of community service, substance abuse evaluation and treatment, risk reduction program, no drugs or alcohol, random screens. Count 2 would merge into count 1, and count 3 would be a $100 suspended fine.
All right. Mr. Lynch?
Because that was my understanding. I believe it's substance abuse evaluation and treatment if recommended. I believe.
Yes.
Yeah. Other than that, Judge, we're just asking the court to accept the plea as negotiated.
All right. So Mr. Ogletree, it looks like from the sentence, that you don't make this a habit, but please learn from this lesson. It is so much cheaper to call a Lyft or Uber or drink at home. And
Yes, ma'am. Yes, ma'am.
So I'm going to accept your plea of guilty to counts 1 and 3. Count 2 will merge. 12 months on count 1, 12 months to serve 1 day credit for time served. The fine is $300, which is going to be closer to $500 or $600 with the surcharges. 40 hours of community service, substance abuse, any treatment abuse evaluation, any treatment that might be ordered, a risk reduction course. You're to have no alcohol or illicit drugs during the course of the probation. You're subject to random screens. Count 3 is a $100 fine suspended, and that will be concurrent with count 1. I'm going to put you in a breakout room as soon as Ms. Nalband is finished speaking with the previous person. And so she's going to be able to get you signed up for probation. She's going to give you information that you need. Ask any questions that you might have. The quickest way to get rearrested is to fail to report for probation. So make sure that you report to probation as directed, and make sure that you answer any questions. Make sure that if you have any questions or difficulties about completing anything, make sure you talk to your probation officers, okay?
Okay, question.
Yes, sir.
I heard it said if recommended for the other things, who would be the one to recommend those?
So you'll do a substance abuse evaluation. They'll give you information about what companies provide those, and it is essentially an assessment to see if you need to have some additional therapy. So if you do not need it, they won't recommend it. If they recommend it, then they'll recommend how many sessions, what level of therapy you need. But so when I say substance abuse evaluation, you take the evaluation and any therapy if ordered. Okay.
Okay. Okay.
All right. So that's what that means. And thank you for that question, because I forget not everybody understands it like I do.
Yes, ma'am.
All right. So, sir, if you will just mute your device, as soon as I'm able to put you in a breakout room with Miss Nalban, I'll put you in there. And then once you have spoken to her, you'll be free to go. Just make sure you do what is necessary for probation.
Okay. Yes, ma'am.
All right. Thank you, sir. Just mute your device. All right, ladies and gentlemen, we have a hearing on Johnson.
Your Honor, I think Mr. Justin Reese, he's present. Can he be excused? I withdrew his motion, but he was present before you.
Yeah, that's fine. Any motions that have been withdrawn, the defendants are free to go at this time unless your attorneys are telling you something different.
And Judge,
Yes.
sorry, I just wanted to make double sure. For Mr. McKinney, I am having a motion or a modification drafted, but is he excused from the courtroom at this point?
Not until, yeah, he's excused. Just make sure he gets the modification.
Absolutely. He understands, Judge, and we contemplated that. Thank you.
All right. Thank you. All righty. Ladies and gentlemen who are coming on for the 11 o'clock calendar, just hold on. I'm going to have a hearing, and then I'll call the 11 o'clock calendar. Mute your devices. This is very important because I don't want to hear the stuff that's going on in the background for you. Ms. Nalban, I'm going to put Mr. Mitchell in with you, and then Mr. Ogletree. So, also, ladies and gentlemen, please make sure that you have your first and last name on the screen. I don't know what nicknames, iPhone, anything like that is not going to help me find you and get you to where you need to be. Marissa with a lot of hearts, that doesn't help me. So please put your first and last name on the screen. Ladies and gentlemen, business is done with first and last names. That's how business is conducted. So please make sure that we are conducting business, okay? Please put your first and last name on the screen, because if I call you and you are unable to respond and I don't see your name, all I see is your phone designation or a bunch of hearts or something, I'm gonna say your motion is dismissed or bench warrant or failure to appear. Something's gonna happen. So please make sure that you put your first and last name, and please get used to that. Let's get used to doing things in a business manner. Ms. Nalban, I put Mr. Mitchell in the breakout room with you, and after Mr. Mitchell, I'll put Mr. Ogletree. Did you have a question for me, ma'am?
For Mr. McKinney, the one with the bond order,
Yes, ma'am.
have him fill out the information sheet. Or are we the ones
Okay.
that?
Yeah, I believe that's already been done.
No, he filled out the probation information sheet, because she's talking about probation, not DUI.
Correct, Judge. Miss and the other, I'm drawing a blank on her last name, but he's filling it out with the other probation officer came down here and provided that to him.
Okay, good. Thank you.
Question was, once doing the screening, just, I just didn't want to, I kind of stepped ahead of the game, but.
No, thank you. Because, yeah, if he has to fill out paperwork, he needs to fill out the problem. All right. So Mr. Mitchell's in the breakout room, and then I'll put Mr. Ogletree in when you're done. All right, ladies and gentlemen, this is going to be a hearing on Marquise Lamont Johnson. Mr. Johnson is represented by Attorney Tortorello. This is case 2022 CR 00705. This is a motion to suppress on DUI less safe, count 1, driving on a suspended or revoked license, count 2, no license, count 3, improper turn, improper signal, count 4, improper lane change, count 5, wrong side of the road, count 6, traffic violation, count 7. And the state is represented by Ms. Stephanie Bing with the Solicitor General's office. All right.
Your Honor, at this time, I'm going to invoke the rule of sequestration under OCGA 24-6-615.
All right. Are there any witnesses here who are likely to or think they might testify on behalf of Mr. Johnson or on behalf of the state in the matter of State versus Marquise Lamont Johnson. Let me know so that I can put you in a breakout room.
Your Honor, I believe there's 2 officers present for this case.
All right. Who's the other officer? Who are the officers? I'm sorry.
I believe it's Officer Discorbeth.
Okay. And who else?
Myself, I'm not sure who is testifying first.
All right. Who's going first?
Discorbeth.
Okay.
All right. All right.
And
Is this Officer Ward?
Yes, ma'am, Lieutenant Ward.
Okay, Lieutenant Ward, I'm going to put you in a breakout room, okay? And then when it's necessary, then we'll bring you out of the breakout room.
Yes, ma'am.
If
All right.
Detective Descorbeth can also be placed in a breakout room. I'm about to do my opening, Your Honor, and then when ASG Bing is ready to call him, he can come out and testify.
Do we need an opening?
I would like to, Your Honor, just to put some things on the record.
Okay, so let me put both of the officers in a breakout room. Ward, let's see, and Discorbeth. Okay, breakout room number 1, Officer Discorbeth. And all right, y'all know there's going to be a lag in getting them back because if I can't talk to them and they can't come right back out, so there may be some a lag in getting them back in and out of the breakout room. But they are
Your
both
Honor,
in breakout room number 1. Go ahead, Ms. Tortorella.
I'm sorry, Your Honor, before we start, can we just take a 5-minute comfort break? I just am having a little bit of.
Okay. All right, we'll be back.
Okay, thank you.
Get the mailbox. Not mailbox.
Ms. Bing, are we ready?
And Your Honor, I see that Officer Christian, who is the officer who initiated the stop, is on the Zoom now. So if he could be placed in the breakout room.
Somebody here is GSP 293. That Georgia State Patrol. Who's that? What's your name, sir?
Yes, ma'am. Trooper Majors, Trooper Marquavius Majors, out of Post 47.
Your Honor, he's the officer on a client's case, Mr. Compton, Damon Compton, on the 11 a.m.
That's fine. I just need a name. All right. Is Miss Bing back?
Yes, I'm back. I'm sorry. I'm here now.
All right, so Officers Christian, Lieutenant Ward, and Officer
Discorbett
are in the breakout room, and Miss Tortorello is ready to do her opening. Go ahead, ma'am.
Yeah, I'm back. I'm here.
I still see D. Christian in the main room, Your Honor.
Officer Christian, go into the breakout room for me, please. I sent you a breakout room invitation.
Honor, I do apologize. If I could be placed in a breakout room with Devontae
Mr. Ogletree?
Yes, ma'am.
All right, no problem. Mr. Ogletree, I'm going to put you in breakout room number 6.
Okay.
All right, Miss Nalban, I'll put you in breakout room number 6.
Thank you, Judge.
No problem.
Your Honor, we are here to ask this honorable court to suppress evidence that stemmed from an illegal stop against Mr. Marquise Johnson. Officer Christian illegally stopped my client because he had no basis for the stop. The state will not be able to provide evidence to support the finding that the stop was legal and did not violate Mr. Johnson's Fourth Amendment rights. Furthermore, if Your Honor does find that the stop was in fact legal, defense is asking this honorable court to suppress evidence that stemmed from the illegal arrest due to lack of probable cause.
Okay.
I guess ASG Bing, you can call your witness.
Well,
I can't.
does Ms. Bing wish to have an opening statement?
Thank you. Yes, I do. Thank you. Your Honor, the defendant was stopped because of a traffic violation. He was observed on the wrong side of the road, and upon further contact, was seen with glassy eyes, red eyes, and the smell of alcoholic beverage on his person. He was pulled into a gas station where officers made contact with him after observing the traffic violation. And he does consent to HGN. He is belligerent. He drops his pants several times, showing his bare bottom half. And he is then arrested because he acted so belligerently that it amounted to a refusal. There certainly was probable cause, and there certainly was cause for arrest. So the state would call one of the three officers that was there, starting with Officer Discorbeth.
One second. Officer Discorbeth, you can come out of the breakout room now. Officer Discorbeth. All right, he's on his way. All right, Officer Discorbeth, raise your right hand for me. Do you solemnly swear or affirm any testimony you give in this matter will be true?
Yes.
All right, you can put your hand down. Ms. Bing, your witness.
Good morning. Can you please state your name for the record?
Regis Discorbeth.
Okay. And can you tell us what you do and where you work?
I'm a detective with the Clayton County Police Department.
Okay. And are you post-certified?
Yes.
Okay. Being post-certified, are you authorized to investigate crimes, make arrests?
Yes.
Okay. Have you done any DUI arrests in your experience?
Yes.
Okay. About how many have you done?
I think about 10.
Okay. How long have you worked for the department?
Almost 5 years.
Okay. Were you on duty January 5th, 2022?
Yes.
Okay. Were you uniformed?
Yes.
Okay. Were you in a marked patrol vehicle?
Yes.
And what were your duties that day?
That day I was on field training with Lieutenant Ward that day.
So, in the field on the road, is that
Yes, it was on
right? Okay. And did you have cause to make contact with, the defendant today?
Yes, we were backing up Officer Christian that initiated the pullover.
Okay. Was that pullover in Clayton County?
Yes.
And was the person that you made contact with when you were backing up, Officer Christian, is he on the platform today? Do you see him?
Yes, he's wearing a hat. He got a Christmas tree behind him.
Okay, great. Did you have your body cam on that day?
Yes.
All right. And can you tell me who else was there? You mentioned Officer Christian, but was anyone else there?
Yes, Lieutenant Ward and Officer Montgomery.
Okay, so Christian, Ward, Montgomery, and Discorvith. Just 4 of you?
There was just 4 of us there.
Okay. Can you describe so you were not there for the initial stop, is that right?
No, I was not there for
Okay,
him.
that's fine. I'm going to share my screen. Give me 1 second. I've not done this on Zoom before, so just bear with me. Give me 1 second.
And Your Honor, I would object to that for lack of foundation.
Object to
you sharing your screen.
Well, you don't know what she's sharing first, Ms. Tortorello. Second of all, because of the limitations of Zoom, I'm gonna have to see something to establish a foundation.
Yeah, well, you tell me. I don't know how you all, normally in court, I would show it just to him, just to the witness. Would you like for me to?
Has he seen what you're gonna show?
It's his body cam. So I want to show it to
Okay,
see if
in
it's
court,
accurate.
you would show a few moments of it. Go
Yeah.
ahead.
Yes.
Overruled.
Are you able to see that?
Yes.
It's coming up.
I'm gonna, geez. I'm just gonna play a few moments for you. Oh.
There's an echo, Your Honor.
That's somebody else is on with more than one device. Please mute your devices. If you're not ASG Bing, please make sure that your device is muted.
I think it's Mr. Lynch.
All right. The courtroom is muted. Mr. Lynch, if you have your own device, mute it, please.
All right. Okay, I don't know if that's enough time for you, but do you recognize this?
Well, we're not seeing that. I'm seeing your screen with a note
Yeah,
about the trial team.
Oh, hold on. Okay, hold on. Let me.
You had it
hold
up and then it went. Then I now
Okay.
just am seeing a starry night.
Okay. Sorry, hang on 1 second. See that?
Nope. Still Starry Night.
Starry Night, okay. That's not my share. Can you see that now?
Yes.
Okay. Oh, can you hear?
Not yet.
Okay, wait, there should be something, so I need to, sorry, 1 second.
You can hear the audio, ASG Bing, you're muted.
Okay, sorry, you can hear it, you say?
Yes.
Okay, awesome. Yeah, I think it's fine now. Thank you so much. Oh, yeah, I think it's, thank you. Okay, Officer Discorbeth, do you recognize this video?
Yes,
Okay, can you tell us what it is?
that's undeniable incident.
Okay, and whose recording device is this?
It's my body cam.
Okay, and is this a fair and accurate representation of that recording?
Yes.
Okay. State moves to admit this body cam as evident as Exhibit A.
Any objection, Ms. Tortorella?
No objection, Your Honor.
Will be admitted without objection, Exhibit A to the motion. All right, Ms. Bing, you need to play it or ask questions about it.
Yes, no, it's okay. I don't want to run into some hearsay issues, so I'm going to use this for another witness. I just want to admit it for through Mr. Discorbeth. If you can share what happened that night when you got on scene.
When we got on scene, the defendant was in the car. I believe Officer Christian asked him to step out.
Objection, hearsay.
Overruled.
When he stepped out of the vehicle, he was asked if he had any weapons on him. Instead of him verbalize that he didn't have any weapon, he had pulled down his pants on his underwear so he can show us he didn't have any weapon on him. When Lieutenant Ward attempted to do SFST, he continued to interrupt her several times. Then he was finally put in custody because he refused to comply with the order. And I believe he also refused when we read implied consent to him.
In your experience, you mentioned that he pulled down his pants, that he was interrupting, he refused to comply. Was his behavior typical of that you might see in a driver that had been drinking?
Yeah, his behavior is saying that he was under something, and he also keeps saying that his mom was a judge in Clayton County Court, that he was gonna get all of us fired.
Objection, hearsay.
The party opponent rule.
Overruled.
Okay. So he was Sorry, you were saying that he was saying that you guys were going to get fired. Anything else?
Um, I mean, he just keep repeating those things that his mom was a judge or was Clayton County, worked for the Clayton County Court, and he continued to refuse to comply, even though I believe Lieutenant Ward asked him several times about the FFST, continued to ask him, and he continued to interrupt and refuse.
No further questions of this witness, although I'd like to retain him for rebuttal.
All right. Officer DeScorbeth, I'm gonna put you back in the breakout room.
Your Honor, I have some cross.
Oh, I'm sorry. Cross-examination from Ms. Tortorello. Go ahead.
Officer DeScorbeth, correct?
Yes,
And you work at the Clayton County Police Department, right?
yes,
And you responded as backup at the Chevron gas station at 130 Southeast Jonesboro. Is that correct?
yes,
Okay. And you just testified that you observed Mr. Johnson being belligerent, outspoken. Is that correct?
yes,
And you just testified that he wasn't cooperating with the officers, correct?
yes.
Okay. Would you agree with me that that could just be that he was angry? When somebody is angry, it could be anger, correct?
Maybe.
It's just yes or no, officer, detective.
Yes.
You don't have to say yes or no if maybe is what he feels is the answer. You can't tell him how to answer, Ms. Tortorello.
Well, in my practice, Your Honor, respectfully, yes or no, but he can explain himself.
If maybe was the answer, maybe is the answer.
Okay. So, you didn't testify as to any other physical manifestations, correct?
I mean, he also had red glassy eyes when we observe when we observe them.
But you didn't testify to that just now, correct?
No, not yet. No.
Okay. And red glassy eyes could be that he was tired. Isn't that right?
Tired, maybe red, but not glassy.
Okay. But you would agree with me that you only saw red glassy eyes, isn't that right?
On the scene, I saw red glassy eyes, but when he had got in the car, he had continued to be outrageous, and that's when I smelled the odor of alcohol.
Okay. Officer, now you're saying that you smell the odor of alcohol, correct?
Yes.
But that's not what you previously stated, right? In your
Ms. Tortorello, you're going down a line, but you're going to keep asking him about what he previously stated. But on direct, Ms. Bing never asked him to describe those things.
Okay, Your Honor, but he just testified that.
But the point you're trying to make is that he didn't testify to those things, but he wasn't asked those questions. So you can keep going down that road, but you understand he's on recall. She put him up to establish the video, but she didn't ask him all of those questions. So you're actually doing her work, is what I'm telling you.
Okay, Your Honor, I understand, Your Honor. She did question him on direct.
I get that, but what I'm saying is you're telling him he didn't say certain things, but she never asked those questions.
Okay, Your Honor. At this time, defense rests. I mean, yes, for Officer Discorvith.
All right. So Officer Discorbeth, I'm gonna put you back in the breakout room. Miss Bing, who's next?
Officer Christian.
Um, All right, so Officer Discorbeth, you're in breakout room number 1. You can just activate your screen and go back in. And Officer Christian, did he leave? Like leave the, no, here he is. Officer Christian,
Hello?
there you are. All right. Officer Discorbeth is going back. He's back in the breakout room. Officer Christian, activate your camera for me. Raise your right hand.
Yes, ma'am. I'm trying to do it now.
No problem. All right, Ms. Tortorella, I'm not trying to tell you how to do your cross, but he's coming back. So I didn't want you to waste time on stuff that he's going to come back for when she never asked those questions.
Yes, Your Honor. Thank you for that. I was making sure that he wasn't going to be released before I asked those questions, but thank you.
No, he's coming back at some point. All right, Officer Christian, raise your right hand for me. Do you solemnly swear or affirm any testimony you give in this matter will be true?
Yes, I do.
All right, you can put your hand down. Miss Bing, your witness.
And can you state your name for the record?
Demetrius Christian.
Your Honor, would you like for him to spell that for Miss
Yeah,
Wright?
that would probably be helpful.
Okay, if you could spell that for us, thank you.
Demetrius, last name Christian, Christian.
Okay. And we're working in 2022.
I was working for Clayton County Police Department.
Okay. And what were you doing for them?
I was assigned the uniform division.
Okay, and were you post certified?
I am.
Were you then?
I am. Yes, I was.
Yeah, okay. And what do you currently do for work?
Right now I work for the postal service.
Okay, so you are no longer with the department.
Correct.
Okay. Were you working for the Clayton County Police Department on January 5th, 2022?
Was.
Okay. Were you uniformed that day
Yes.
and in a marked vehicle?
Yes.
Did you make contact with Mr. Johnson that day?
Yes, I did.
Okay. Can you tell us why you made contact with Mr. Johnson?
I observed Mr. Johnson speeding and driving on the wrong side of traffic, passing 3 vehicles at a high rate of speed. He also ran a stop sign, which I had stopped him for on Highway 138 in Jonesboro.
Did he ever, okay. Did he ever admit to those things during the stop?
Did he ever admit to the things during the stop? No, he did not.
Okay. Okay. I'm going to, I'm sorry. Say that once. Did you say you did not recall or
No, I do not recall.
Okay. If I showed you a video from the body cam, would that refresh your recollection?
Yes, ma'am.
Okay. Let me see here. Your Honor, am I free to play this in just openly? I mean, for recollection, I don't know. It's fine. It's based on your expression.
Yeah,
I can
go
say it's
ahead.
fine. All right. Okay. Can you see that? Can the court see that?
Yes.
I am going to play about 10 minutes and 54 seconds.
Your Honor, I will object to this. The rules of evidence are about writings to refresh recollection, not video. So if Officer Christian needs to review his police report, that's fine, but we will object to this. If she wants to play the whole video before testimony, his testimony, that's fine. But unless she wants to impeach.
Okay, it's in evidence. She can play whatever part she wants. If you want rule of completeness, then you can play it after she plays what part she. If she's playing it to ask him questions about it, she's allowed to do that. If it's not a written document, then maybe he can't refresh his recollection. But if she wishes to ask him to review the video and answer questions about the video, she can do that because it's in evidence.
Yes, that's what I was objecting
Okay.
to.
So, Ms. Bing, it's not a written document for him to refresh his recollection, but did you wish to play portions of the video and ask him questions?
Yes.
All right.
Okay. Hold on. I'm trying. Give me a second to. Okay. See. Okay,
Bro, get your license, man. Have him step out. Get his ass off the phone. Step off the phone.
oh wait, hold on. This is.
FTA. It's a little roaches out there. I don't know what it's called.
I'm having a hard time seeing
You know
that.
my dad is.
Okay. What are you trying to do? Get to
I'm
a
sorry.
particular point?
I am, but I can't quite see the timestamp. It's different.
Okay, I can tell you what the timestamp is. It's 13:35, 10:20. Then you went back. It's 11:24, 11:03, 9:59.
Okay, I'm trying to play from
10:41.
here. Yeah.
From 10:41.
Yeah, it should be 10:41.
Okay, you do it.
Okay,
Let's go. Let's go.
Come on, stop talking.
Okay, hold on, hold on. Mr. Christian, what's going on?
She just explained to you.
Okay. So I'm saying, you run my name, you had my information.
First of all, let's get something straight. Let's get something straight.
Okay,
Let's get something straight.
I'll keep my voice.
You cut off 3 cars going into oncoming traffic. You were speeding on a 35. It was 35 miles per hour. You was doing at least 60. It took me 70 to catch up to you. All right? You ran the stop sign. You ran the stop sign on my side. I mean North Main Street. Come and then made a left turn. I lit you up right over here.
You gonna do that to me, Mr. Christian?
Man,
And I ain't saying you won't. I ain't saying you won't.
Okay. Mr. Christian, do you hear Mr. Johnson say, I ain't saying you wrong?
Correct. Yes, I do.
Okay. So he's saying that in response to your
What I just told
description.
him.
Yeah.
Yes.
And what you described in the video, is that what the reason why you pulled him over?
Yes, that was my probable cause.
Okay. Okay. Can Can you tell me at what point and why there was well, let me back up. Was there ever a DUI investigation or an attempt for a DUI investigation during that
Yes,
stop?
it was. Yes.
Okay. Can you tell me the reason why a DUI investigation had begun?
He had admitted to having one beer, and he was admitted to coming from a club off of Old National.
Okay. Was there anything else?
The red glazy eyes that I observed, and he pulled up when I asked him if he had anything on him. He pulled his pants down multiple times, and that just gave me a red flag. Me and all other officers.
Is that is that behavior that you have seen before, that or those observations that you've made before when you're dealing with a DUI case?
The red glazy eyes, yes. Pulling down the pants was unusual, so that was the first time dealing with that one.
Okay. Did you attempt to do field sobriety on him?
Yes, Officer Ward attempted to do fields.
And was she successful?
No. He agreed, and then
okay. Did you read implied, was implied consent read?
Yes, it was.
Did you read implied consent, or did someone else?
Someone else.
You remember who did?
Officer Ward.
And did he agree to consent to implied consent?
He did at first, and then he declined later on.
Did he explicitly decline, or was his behavior, or did
No,
you?
it was his behavior. He got to yelling. His mom was a judge, and he got irate, and I kind of just said, "Okay, we just gonna take him into jail because he was irate."
All right, thank you. That concludes my questions, but I'd like to hold you as for later.
Okay.
All right, Ms. Tortorello, cross-examination.
Yes, Your Honor, if you can give me a second to pull up the video. And I'm just going to share my screen as I do cross. 1 second. I'll share my screen if I need to, Your Honor. Okay, Officer Christian, correct?
Yes.
And you work for Clayton County Sheriff's Office, right? I mean,
No,
you
I did, and I worked for Clayton County Police Department.
Okay. And currently you work at the post office, you said?
Yes.
And you initiated the stop against Mr. Johnson on January 1st of 2022, correct?
Correct.
And you stopped Mr. Johnson due to several traffic violations you observed, correct?
Correct.
And the stop was at a Chevron gas station on 130 Southeast in Jonesboro?
Yes.
Okay. And you made contact with Mr. Johnson. He wanted to know why you pulled him over, right?
Yes.
Okay. And you responded, and I quote, "You know why I pulled you over," end quote. Isn't that right?
Yes.
Okay. You didn't initially advise my client of the reason why he was pulled over, correct?
No, not initially. No. The reason being because he was irate. He was he was on the phone. He wasn't paying attention as well, and he was yelling.
And you eventually tell my client he ran 3 stop signs and ran quote, the light down there, end quote.
Okay.
And then you said Mr. Johnson speeded and went across 2 cars, isn't that right?
He went across 3 cars, I believe. Driving the wrong way.
I'm gonna now share my screen, and I believe this is minute 1. Your Honor, I'm gonna start the video at minute mark time mark 1 minute 45 seconds.
Okay.
Right there. Good grief. We'll just start here.
Help him on this one. Yeah, you can see, you went across 2 cars, and you started to get down the car. Hold on. Why you saying, oh, no, there's nothing on me, sir. I asked you a couple times, get your lights up. Step out, get his ass off the car. Step out the car, please. Step out. First of all, you ran through. Open the door, Christian. Ran the light down there. Yeah. Step out, man. Step out. Help him on this side. Yeah, you can see, you went across 2 cars, and you started to.
Did you hear yourself right there, Mr. Christian?
Okay.
You stated there you went across 2 cars, isn't that right?
Yes.
Okay. And Mr. Johnson wasn't slurring his words when you spoke to him, isn't that right?
He wasn't slurring his words.
You're saying, can you repeat your answer, please?
You asked me, was he slurring his words?
Correct.
I testified that he had.
Objection, I'm sorry. There was no mention in cross that about slurring words. I mean, I'm indirect about slurring words.
But this is her first cross, so she gets to ask these questions. Go ahead, ma'am.
So, what was your answer, Mr. Christian?
No, I can't recall.
Okay. He was actually angry and questioning you about why he was stopped, right?
Okay. Yes.
And he pulled his pants down, right?
Yes.
He just wanted to assure you he had nothing on him, isn't that right?
That's what he said, but you don't pull your pants down when we could just search you. That's unusual. He pulled them down twice.
Well, wouldn't you agree with
What
me?
was the reason for the second time?
Okay. If you can please stick to the question being asked. Okay. So you're saying that if you can answer clearly again. So my question was, he just wanted to assure you he had nothing on him. Isn't that right? And your response?
Ms. Tortorello, that's been asked and answered. He said that happened the first time. Why did he pull his pants down the second time? He already said he did that in response to that.
Okay. And he did this because you asked him if he had weapons on his person, correct?
Yes.
Okay. And he addressed you by your last name at one point, right, officer?
Yes.
Okay. If he was impaired, he wouldn't have been paying attention to your name. Wouldn't you agree if he was that impaired?
That's not true.
Okay. In fact, you proceeded to ask him after you learned he knew yours about his name. Isn't that right?
Yes.
But you're the one that initiated the stop.
Yes.
So you should have known his name by now. Isn't that right?
How can I know his name when he was refusing to give me his ID during the court when I was asking for it?
Okay. So at what point did you get his ID or identify him?
Finally, when we got into the rear of the vehicle, I was able to ask him for his name and he finally gave it to me.
Okay. I'm going to play. I'm going to start at 5:55, Your Honor. Minute mark, 5 minutes and 55 seconds. I can.
It is.
But I'm saying you finna charge me with that?
Did I say I was gonna charge you with
Okay,
that?
you're right. My fault, Mr. Chris. My fault.
What's your name?
Hey, Marquis.
What?
Damn, bro.
Mar what?
Marquis.
MARQUIS?
Yes, sir.
What's your last name?
JOHNSON, man.
Mr. Christian, wouldn't you agree with me that this was before he got in the back of your patrol car?
Yes, that's before he got in the back of my patrol car.
And he
Yes,
identified himself to you at that point, correct?
correct.
And you were writing a citation at that point, isn't that right?
No, I'm writing his name down.
Okay, what is that paperwork you're writing on?
I'm not sure. I can't recall, but I know I'm writing his name down.
Okay.
In fact, after that, I went and checked his name that I could recall.
Mm-hmm.
So
he had no problem giving you his name and date of birth, correct?
he did have a problem with it.
Okay, let's go back to the video.
You going back to that video, but when we initiated the first time, he had a problem with providing his name and date of birth.
But he had no problem on giving the date of birth to you eventually, isn't that right?
After,
And again, this was before he went on the back of your
No.
patrol car.
I'm not understanding what you trying to ask.
It's okay. I'm gonna play a video at 6 minutes, Your Honor.
Your Honor, before she does, I have to
Sarah, what are
object
you
to
asking?
relevance. Yeah.
Because he said he was at the back, he was at the rear of the vehicle when he gave me his name. I looked at the video. The man was leaning on the rear of the vehicle when he gave his name. What's the question?
Your Honor, the
What's the
question
point you're trying to make?
that Mr. Johnson was able to provide Mr. Christian his name and date of birth. So he was able to articulate that to the officer accurately, Your Honor.
Okay, we just saw that.
Okay. And you advised my client that he cut cars going into oncoming traffic, and he was speeding, going 60 in a 35-mile-per-hour zone. Isn't that right?
Yes,
Then you told him it took you 70 miles per hour to catch up to him. Isn't that right?
correct.
And then you said he ran the stop sign on North Main Street and then made a left turn, correct?
Yes,
But you previously told him he ran 3 stop signs and ran a red light and speeded across 2 cars. Isn't that right?
I can't recall.
Okay. You just testified that's what you said initially on video.
That he ran stop sign. That he ran a stop sign. Yes,
And he went past 2 vehicles.
he went past at least 2 or 3 vehicles from my
Okay.
recollection.
All right.
He drove on the wrong side of the road,
Okay.
passing those vehicles.
But that's not what you initially told him about at the stop. You didn't advise them that he drove on the wrong side of the road. Isn't that
Okay,
right?
sometimes when you're frustrated, it don't come out right then and there. But I told him of it.
So which one is it, officer?
I'm not. I just told
Your
you.
Honor,
I'm not understanding
Your Honor,
what you're trying to.
I have to object. This is kind of harassing and badgering. I think this has been beleaguered.
Your officer, where is you had a dash cam, correct?
Yes.
Okay. Why were you, and you weren't able to, and where is that dash cam?
That's an older vehicle, so I might not have the dash cam at that time. I
But
may
you
have, I may
recorded,
not.
you were able to record the stop on your dash?
I'm not sure. If it's that old vehicle that I used to drive, I believe the dash cam didn't work. Or it might have.
And your body cam, did you have body cam on you that day?
Yes, I did.
And where is that?
You got
Were
to
you able
contact the department.
The state didn't ask you for your dash cam and body cam?
Ma'am, you got to contact the department. I don't provide that.
Okay. And what about an incident report? Did you ever write an incident report?
I don't recall. You asked me something. It's 20 something, 22 or something like that.
So you don't recall writing a police report on the stop that you made that day, correct?
Correct.
Okay.
I don't recall.
You think that's something important to have, officer?
I don't recall if I wrote one or not, ma'am.
I'm just asking if you think it's important to have a police report.
That's why we wear body cams as well.
But you're also trained to write an incident report, isn't that right?
Am I trained to write an incident report?
In your training, you've been trained to
Yes, I know how to write an incident report.
okay, for your cases, correct?
Yes, for regulation.
Especially if you are an officer initiating a stop for a DUI.
I initiated the stop. May I say something?
Hold on, Officer Christian. Ms. Tortorello, if you're challenging probable cause, the probable cause for the stop was the traffic violations. I've heard enough to establish probable cause for that. If you're challenging the DUI, that's not what you initially said. If he didn't have, no, you said you're challenging the probable cause for the stop. And if he didn't have probable cause for the stop, then you're challenging everything else that came after for the DUI investigation. He and Officer Discorbett have established enough for a probable cause to stop this man.
Okay, Your Honor.
I'm not sure where we're going with this.
I just want to put some things on record, Your Honor, in case this gets to trial.
But if what you asked for was probable cause for the stop, we have more than that.
Okay. Yes, Your Honor. Defense rests.
All right.
Officer Christian.
Anything else from the state?
Just closing then.
All right. All right, I'll hear from the state. I'll hear from the defense.
Your Honor.
Yes.
Do I need to be here?
No,
I
you're
got
free to
low.
go. You're free to go. I got you. You got to get the mail out.
Thank you, ma'am.
Neither sleet, nor storm, nor subpoena.
All right. Thank you.
Take care. Be safe. All right.
All right. You too, ma'am.
Argument.
State first?
Yeah, that's fine.
Okay. Your Honor, Frederick v. State, 270 Georgia Ave 397 says the defendant admitted that he had been drinking. The officer smelled a strong odor of alcohol on the defendant's.
Your Honor.
First of all, I don't care about that because she's challenging probable cause for the stop. Let's stick to that.
Your Honor, in my opening, I was challenging the illegal stop and then probable cause for DUI arrest. That was in my opening.
That's what you said. I wrote it down. You said you were challenging probable cause for the arrest or for the stop, and that you wanted anything after that suppressed.
No, I said, and I actually write down my statements, Your Honor, and respectfully, I'm asking the Honorable Court to suppress evidence that stemmed from the illegal arrest due to lack of probable cause.
But if there's probable cause, the arrest was not illegal.
For DUI? Okay. Yes, Your Honor. For DUI, Your Honor.
He didn't stop him for DUI, Ms. Tortorello.
Yes, Your Honor, but he was charged with DUI.
Right, because there was a subsequent arrest. But you asked for probable cause for the stop.
No, I asked for to suppress evidence that stemmed from the illegal arrest due to lack of probable cause.
Argument. Go ahead, Ms. Bing.
Okay. Sorry, I was beginning and you said you didn't want to hear that?
No, go ahead. I want to hear it now.
Okay.
Let's get everything on the table.
Okay, so Frederick v. State, 2270 Georgia App 397, states that the defendant admitted that he had been drinking and the officer smelled a strong odor of alcohol on the defendant's person, observed the defendant's eyes were glassy. The court held that the arresting officer had probable cause to arrest for less safe DUI. State v. Sledge, 264 Georgia App 612. The Georgia Court of Appeals has found that even in the absence of field sobriety tests and officer's observation that the suspect has bloodshot, watery eyes, exudes an odor of alcohol is sufficient to show probable cause to arrest the suspect for driving under the influence. So here, officers observed him on the wrong side of the road, glossy eyes, red eyes, smelled strongly of alcohol. He admitted to alcohol at a bar. Officers are free to stop motorists for traffic violations. And if and when they make contact, the officer observes additional reason to continue his investigation, he may do so. We saw the body cam starting at 10 minutes and 54 seconds that Officer Christian said to him that he cut off 3 cars. Whether it's 2 cars or 3 cars, it doesn't matter. It was an erratic and unsafe violation. He went into oncoming traffic. He was speeding. Took him up to 70 miles an hour to catch him. That was the reason for the stop. After making contact, officers observed those physical evidences of having of a person that's been drinking. And because of his belligerence and refusal and observations, there's certainly probable cause to arrest the defendant. And so we would ask the court to find probable cause for this arrest.
All right, Ms. Tortorella?
Your Honor, based on witness's testimony, we are not challenging the stop. However, we are challenging lack of probable cause for a DUI arrest. Your Honor, the rule is well established that evidence which shows only that the defendant had alcohol in her body while driving provides insufficient probable cause to arrest for State versus D'Amato, 302 Georgia App 181, 2010. The Court of Appeals reasoned that impaired driving ability depends solely upon an individual's response to alcohol. Because individual responses to alcohol vary, the presence of alcohol in the defendant's body by itself does not support an inference that the defendant was an impaired driver. According to the Court of Appeals, odor of alcohol emitting from a person admitting and a positive PBT result is not enough probable cause for a DUI arrest. In D'Amato, the defendant was also in a one-car accident with a deer. Furthermore, while bloodshot eyes and slightly pale skin may support a finding of impairment, such evidence does not require a finding of impairment. Here, Your Honor, Officer Ward, the officer who actually did the DUI investigation, didn't even testify as to her DUI investigation. Officer Christian alleges traffic infractions and statements about those infractions, which were inconsistent. Moreover, the officer didn't even recall whether or not he wrote a report regarding those traffic infractions. Mr. Johnson was also not slurring his words. The state only has an admission of drinking a beer and bloodshot eyes, which do not require a finding of impairment. Therefore, Your Honor should find that there wasn't enough probable cause to arrest Mr. Johnson for DUI less safe, and everything after the arrest is fruit of the poisonous tree and should be suppressed. Nothing further.
So the court observed the officers, Officer Christian, who admitted to being frustrated. So when he was fussing at Mr. Johnson at the initial stop, he said he wasn't able to really tell him because he got frustrated and it wasn't coming out. So he said he passed 2 cars, he passed 3 cars. But when he stated it at the rear of the vehicle, he talked about his manner of driving, which is important for DUI less safe, because if someone observes the manner of driving, that also is a clue for impairment. He was on the wrong side of the road. He was passing cars. He blew through stop sign. He was driving in an erratic manner. They pull him over at the gas station. He won't give his name initially. He won't give his date of birth initially. Officer Christian or former Officer Christian testified to that. It wasn't until they got him out of the car, he gets to the rear of the vehicle, and then he can give his name. Officer Christian and Officer Descorbett observed red, glassy eyes. They observed the smell of alcohol on him. He admitted to drinking alcohol. He admitted to coming from a nightclub. He was combative with the officers, and when Lieutenant Ward attempted to do a field sobriety exercises, he agreed, then he disagreed, and then he was combatant. But one of the most telling things is he pulled his pants down twice. So in the grouping of things that officers can consider for a probable cause for a DUI investigation and thus a DUI arrest, all of those things, it might not be one thing, it might not be two things, it might not be three things, but he was driving on the wrong side of the road. He pulled his pants down twice. He smelled of alcohol. He was coming from a nightclub. He was combative. Initially, he wouldn't give his name or date of birth. All of those things. So when you make your argument, Ms. Tortorello, you can't just argue the things that you want because they make your client look good. It's the whole grouping of things. Yeah, you're agreeing to the fact that there's probable cause for the arrest, but part of the arrest was he was driving on the wrong side of the road. That is also something the officers observed. And for DUI less safe, we're not talking about DUI per se, but for DUI less safe, the manner of driving is an indicator. So the court finds that there's sufficient probable cause for the initial stop and the DUI arrest. Motion to suppress denied. All right, so the 11 o'clock calendar, thank you all for your patience. I'm going to go ahead and call the calendar. Y'all give me information about the cases and whether we're going forward with hearings. All right, first case on the calendar is Micaiah Christian Belk. This motion was withdrawn on 12/8.
Yes, Your Honor, can my client be excused? He's
Next case is Priscilla Butts. This is a motion for immunity.
Your Honor, we're moving forward on the motion.
All right, hearing. Next is Damian Gerard Compton.
That will be a hearing, Your Honor.
Next is Kaylin Fuller.
Your Honor, and I spoke to Mr. Barton. I don't know if he's there. Oh, great, he's there.
I'm coming up to the camera here. We were waiting patiently in the jury box. Judge, good afternoon. Judge, I've got three motions today. I've got a constitutional speedy motion, and we've got also a motion regarding the search warrant that exceeded the scope of the search warrant for the blood testing, and we have another motion in limine for the way the blood test was done. So we've got three motions.
So you're asking for a Daubert motion on the testing?
Right, Judge, the blood test motion is the third one here, and we're just examining. It's a motion in limine seeking exclusion of the medical blood test.
No, I'm asking, is this a Daubert test where we have to get into the experts? What are we doing?
No, Judge. It's just, the qualifications of the phlebotomist, the testing, stoppering, that kind of stuff. So,
all right.
All that. So we've got those motions now. if the state wants to have a conference with me about the case, I'll be
Yeah,
glad.
I would like to have a conference because when we spoke yesterday, you told me to just send you a rec that we were going to work this out. So
Well, yeah,
yeah, that was the conversation.
yeah, but I never got a rec, so we need to, and so that's why if you want to have a discussion, I'll be glad.
We
to do
did. Okay,
Yeah, be glad to speak with you about it.
sure,
okay?
we can have a conference.
But we'll be prepared to go forward if that doesn't work out, Judge.
All right, the last case on the calendar is, oh, I'm sorry, not the last case. Grant, Talik Renard Grant wishes to withdraw his plea.
No, ma'am.
I'm sorry?
Yes, ma'am. He wishes to withdraw his plea. Yes, ma'am. But we're not ready to go forward. We filed a motion for a copy of the transcript. We've been trying to reach Mr. Lynch to see if we could get discovery from him. We don't have anything to go, enough information to go forward today.
And Mr. Hicks, I do apologize if I missed you. I did speak with your assistant. I'm happy to get with you anytime you're ready, sir.
Thank you.
Yeah, well, who has the transcript? Who are we requesting the transcript from?
A transcript of the plea.
Right, but generally Ms. Martin files her transcript. So if there's a request for a transcript, it should be already filed. If it's not, then you got to request that from Ms. Martin.
I always file it with the court, and once you tell me yes, I can get a copy of it, and that the administrator is going to pay for it because obviously he's.
All right, submit an order.
Thank you, ma'am. I will.
All right. Okay, so the grant motion will be moved to the next available motions calendar. You all will have the opportunity to get the discovery and the transcript. All right,
January
Terry.
12th. January 12th, Judge.
Can we move it out a little further, Ms. Val?
Okay, well, we'll notice him.
Okay, thank you.
Thank you, Judge. That's all I have.
Thanks to Mr. Hicks. All right, Holmes, Terry Eugene.
I believe that's been reset. I believe that was reset for January 12th.
And Judge, I am present on that case. My name is Mary Agramonte. I'm with Scott Smith's law firm. I believe it had been reset due to the assigned lawyer's leave of absence, but due to the nature of the motion, I believe we had reached out to your office and we were told that if possible, and I'm happy to pre-try it with ASG Bing as well.
Well, you can pre-try it, but if it's already been moved to the January calendar, that means that they probably haven't brought their witnesses.
The alleged victim is on the call, and I believe she has spoken with their office, but I don't believe this should be too complicated of an issue. So I'll pre-try it to see if we can get it worked out via consent.
All right.
Thank you, Judge.
All right. All right, Joylisa Whalen Hubbard.
Your Honor, my understanding is that this is an order. I will have to write an order because I believe the state has consented to the modification. I'm not sure if ASG Bing has to put her victim on the record. But this is basically modifying for no violent harassing contact and for her to be able to return to her to the home that she shares with her husband.
I spoke with the victim and I believe he is on or was on. If he's not on right now, I'll have our victim's advocate reach out, but he is completely cooperative. So he's
Okay,
just
then-
going to make a statement to say, that this is what he wants.
All right, that's fine. I do need an order. Jeffrey Scott Keith.
Good morning, Your Honor. We're withdrawing our motions. We worked out a negotiated plea with Ms. Bing. I don't know if you want to handle it today or on a.
Yeah, I want to enter it right now. Where's Mr. Keith?
He's coming up, Your Honor.
All right.
And I've gone over the waiver rights form with him in the courtroom.
All right. All right. Raise your right hand for me, sir. Do you solemnly swear or affirm any testimony you give in this matter will be true?
Yes.
All right, you can put your hand down. You're before the court on State of Georgia versus Jeffrey Scott Keith. Mr. James Sullivan is with you at the podium. Mr. Sullivan, what does your client plead to the offenses before the court? DUI, DUI less safe, improper lane change.
Your Honor, he's pleading to one count of DUI. I believe Ms. Bing is going to merge the other counts, if I'm not mistaken.
Second.
All right, the improper lane change.
The improper lane change doesn't get merged into DUI, but DUI less safe does.
Ms.
So
Bing,
the third count's gonna.
improper lane change. Will you be non-prosing that?
Sorry, who am I speaking with?
Mr. Sullivan.
Oh, we can suspend the fine.
That's fine.
That's cool. Okay.
All right. So, Mr. Keith, by entering a plea of guilty to counts 1 and 3, count 2 will merge. You give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself. And if you are not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things?
Yes, I do.
All right, factual basis recommendation, please.
January 1st, 2022, officers responded to a two vehicle accident. When officers made contact with Mr. Keith, he immediately observed the driver's glassy eyes. He also detected an odor of alcoholic beverage coming from him. He asked Mr. Keith if he had had an alcoholic beverage. He did say yes, that he had had a beer. He was determined at the end of the accident to be the at-fault driver. And he did attempt, officer did attempt HGN. Oh, and sorry. They did do HGN. They saw 4 out of 6 clues. Saw 4 out of 8 clues for the walk and turn, and 2 out of 4 for the one leg stand. He was read implied consent. He did agree. His blood alcohol level was 0.168. The state's recommendation is 12 months to serve 1 day, credit for time served, balance probated, a $300 fine, 40 hours of community service, substance abuse evaluation and recommended treatment, no drugs or alcohol, DUI risk reduction, and a victim impact panel. Count 2 is merged into count 1, and count 3, improper lane change, is a $100 suspended fine.
All right. Mr. Sullivan.
Your Honor, we'd ask that you accept the negotiated plea. I know this plea is being handled via Zoom. Are we able to go to the clerk's office to ask for the first offender affidavit?
You may.
Thank you.
All right. So, Mr. Keith, I'm going to accept your plea of guilty to counts 1 and 3. Count 2 will merge. 12 months to serve, 1 day, credit for time served. Balance will be probated for a fine in the amount of $300. You're probably looking at more like $700. 40 hours of community service, substance abuse evaluation, and any treatment that they may order you to take. No alcohol or illicit drugs during the course of your probation. You're subject to random screens for alcohol or drugs. You'll do 1 victim impact panel and present the information to probation. Count 3 will run concurrent with count 1. and that's $100 suspended fine. Mr. Keith, when you leave the courtroom, you're going to go to the courtroom next door, courtroom 305 to your right. You'll go into the first set of double doors, and Ms. Nalband is there from probation. She'll get you signed up. The quickest way to get rearrested is to fail to go to your probation reports. Also, if you have difficulty finishing or completing anything that I've ordered you to do, you need to discuss that with your probation officers. They are here to help you successfully complete probation. And as an aside, Mr. Keith, this looks to be your either first in life or first DUI in 5. Mr. Sullivan is asking for a conviction, a certificate of first conviction. So this is your first. Let it be your last. We got a lot of stuff that we can do other than drink and drive. We can stay home. We can call a ride share. We can call a cousin. We can ride with a designated driver. But what we don't need, life at risk. Are we clear? Now, the holidays are coming up. You can have no alcohol or illicit drugs. Don't listen to the friends who say one taste won't hurt you, because if you test positive for alcohol and drugs, you and I will be having another conversation. Do you understand?
Yes, I do.
All right. When you leave the courtroom, go to your right, sign up with Ms. Nalband. Do not leave the courthouse without it. And Mr. Sullivan, you can get the certificate of first conviction from the clerk's office on the first floor.
Thank you, Your Honor. Always a pleasure.
All right, take care. All right, next is Amaya Kamora Neely Lloyd.
Your Honor, that motion was withdrawn yesterday.
Okay, thank you. Next is James Antoine Murphy.
Judge, I filed a withdrawal from Mr. Murphy's case yesterday.
All right. Cornelia Nash. Kim Phillips is the attorney. Was withdrawn on 12/5. Anybody on that case? If you don't have anything else, you're free to go.
Your
Yes.
Honor, we have
Yes.
the witness. We have the witness who was subpoenaed for Ms. Nash's case. She's been sitting here about an hour waiting to speak.
Okay. And you are?
I'm her attorney.
All right. So Ms. Nash's attorney has dismissed the motion. So there's nothing to go forward on. If the witness is in contact with the Solicitor General's office, their victim witness advocates, they will be in touch with her about the trial in this case. I don't have a current trial date, but at some point she'll be given notice.
Okay, thank you, Your Honor.
You're welcome. All right, next is Terrence Vince Raymond.
Good afternoon.
I'm sorry, I had that somebody had a conflict, but you're here.
Yes, Your Honor.
Okay.
I just need a moment to continue pre-trying with ASG being.
All right. All right, the next case is Kadarius Woods. Lister Home Dennis, I have that the notice was returned.
Judge, I filed a withdrawal from Mr. Wood's motion as well.
All right, so I have hearings on Butts, Compton, possibly Fuller, and pre-try on Raymond. All right, Ms. Bing, go ahead and talk to Ms. Reed and Mr. Barton, and then we'll do the hearings on the Butts, Compton, and Fuller.
Okay, and Your Honor, just for clarity, on Ms. Hubbard's case, are we going to wait for the alleged victim to come on the record? Is that
well?
I don't know who we're talking
about. Sorry. Yes, for the Hubbard case, I mentioned that the victim was cooperative and wanted to come on. He was on, then popped out, I guess, and so Ms. Hemphill is contacting. Oh, I'm sorry. Actually, she did tell me they're in the courtroom. That's why I didn't see them on here.
Okay.
So we can do a consent. We'll do a consent order after that person speaks.
Okay, I just wanted to make sure because my client was wondering if she could be released.
Okay, well, do we want to bring him up? Bring up, who is it?
Jacardo Hubbard.
Come on up, Mr. Hubbard.
Hey, how you doing?
Raise your right hand for me, sir. You solemnly swear or affirm any testimony you give in this matter will be true.
Yes, ma'am.
All right, you can put your hand down, Ms. Bing, your witness.
Miss Bing, you're on mute. I'm sorry.
Yes, I'm so sorry. Mr. Hubbard, hello.
Hey, how you doing?
Can you just state your name and spell it for the record, please?
Jacardo Hubbard, JACARDOHUBBARD.
Okay. And what's your relationship with Joy Lisa Hubbard?
My wife.
Okay. And what is it that you'd like the court to know?
I want her to come back home.
Okay. Do you have any safety concerns?
Nope.
No. Okay. And you were the victim in this current case, is that right? Okay. All right. That concludes my questions.
All right, so Mr. Hubbard, Ms. Hubbard, the state and the defense have consented to a modification. Mr. Hubbard has put on the record that he doesn't have any concerns. My concern is whatever precipitated this, y'all know what it is. I'm not getting in your business, but whatever it is, y'all need to work that out. Whether you need to go to counseling, whether you need to, I don't care what kind of counseling you get, but y'all need to work that out. Because if it happened one time, if there's a lack of trust in a relationship that leads to this kind of thing, then it's going to happen again. If y'all are at the point where we looking at phones and trying to figure out if people doing certain things, then your relationship is pretty much over at that point. Anytime I got to check up on somebody that I am supposed to be in a relationship with, if you want to save it, you know, you might want to go to counseling and see if it'll work out. But don't just come back to square one and with no changes. If y'all are modifying so y'all can be in the same house, don't just go back to square one thinking this won't happen again. Because whatever made it happen the first time is likely to happen again until y'all fix it. Are we clear, Mrs. Hubbard? You're on mute.
Yes.
Just because y'all grinning and feeling good about each other right now, whatever happened when that happened, y'all wasn't grinning and feeling good about each other. So whatever is the bottom line, the source, the issue is still there. I'm just be honest with you. If it happened once, it can happen again. All right. So they'll give me the consent order. Just to be clear, Ms. Hubbard, that means that you can have contact of a non-violent or non-harassing excuse me, nature with your husband. If y'all choose to use that time to get counseling, either individual or together, that's fine. It may benefit you. But whatever the issue was that led to this, it's still there. All right, free to go at this time. Your attorneys will get you the copies of the motion
And
of the modification.
Just to be clear for the record, she's also allowed to return to the home. Is that right?
Yes, put that in the motion. I mean, put that in the modification.
All right, thank you.
Ms. Hubbard, you can lead the meeting.
All right, thank you.
All right, keep in touch with your attorneys.
Your Honor, I have an announcement on butts.
Yes.
Our witness has at the last minute chosen not to appear.
Okay.
So we're gonna have to not process that, I guess.
All right, Miss Tortorello. Who's butts is Tortorello?
If I can, yes, I gotta see how old.
It's a no process, Miss Tortorello. You got an objection to that?
I technically don't, but the state can always bring back, I've seen it in the past, they can always bring back a case once they have their.
Yep.
So I just want to see, I just want to discuss it with my client and then just kind of look at the case. I need to go over the date.
Okay.
Hold on a second.
All right. So, Mr. Barton and Miss Bing and Miss Reed and Miss Bing are gonna. Miss Agramante, did you need a conference or are you ready to go forward with a hearing?
We can start with the conference.
All right. So, Mr. Barton, Miss Bing, did you want to go down to the courtroom and speak to Mr. Barton, or did you want a conference
Come
with
down to
him?
your office.
Oh yeah, come on down to the office.
Okay, I'll do that.
All right.
All right.
And so
Get that
once
way
y'all
right
are
now.
finished speaking, I'm sorry. Okay, once y'all are finished speaking, then let me know and I'll put you in a breakout room with Miss Reed and Miss Agramante. Or Miss Reed might be here. She might be able to walk down there also.
Just a little bit.
All right. I'll be waiting for an announcement. Ladies and gentlemen, let me just tell you what's going on because I know it's confusing. So I've called the calendar. Announcements have been made. Some cases are going forward. Some cases are not going forward with hearings. Those cases that are not going forward, those cases where I've said it's going to be reset or it's a withdrawal, anybody on those cases, Grant is going to be moved to the next available calendar sometime in February. Holmes is a reset. Keith is a plea, so that's been done. Hubbard is a consent modification, so that's done. Lloyd is a withdrawal. Murphy is a withdrawal. Nash is a withdrawal, and Woods withdrawal. So all of the individuals on those cases, if you do not have anything else at this time, you are free to go. Anyone else, please remain until we announce on your case. Miss Butts, technically your case has been null pros. So I'll sign a null pros, but my understanding is your attorney wants to speak with you. So you can speak with her about the case so she can explain what that means.
Yes, Your
Yes,
Honor.
ma'am.
I'll speak with her, but just for the record, no problem with the null pros. Obviously, it's obviously up to the state at any point, but
So Ms. Butts, you're free to go if you want.
Okay, may I ask a question, please? As far as no process, I heard.
Wait, Ms. Butts, take it down.
I'm sorry.
The reason I'm cautioning you about asking a question is because the state could possibly bring this case back. What I don't
That's
want
the
you to
point.
do is ask some questions that could give them information that goes against your Fifth Amendment right to remain silent. What I was about to say to you is, why don't you log off and then either later this afternoon or tomorrow, because we don't have court tomorrow, call Ms. Tortorello and speak to her about the implications of the null pros.
Yes, Your Honor. I wasn't going to ask about the case. I was going to ask about the null pros in itself.
I got you. A null pros means that they are not prosecuting the case, but the state has a period of time after a null pros where they can bring the case back. So that's what I want you to talk to Ms. Tortorello about. That's the information I can give you at this time. Ms. Tortorello is going to be able to give you more specific information. What I'm saying to you is call her either later this afternoon when we're finished or tomorrow when she doesn't have court so that you can get more information and ask all the questions that you wish to ask. Okay?
Okay.
All right, just take a breath. Just breathe.
I'm just
because
trying
I
to
know
understand.
It's
I don't
urgent
want
right now. But what I'm saying to you is she will explain everything you need to know. I just don't want you trying. Her attention is divided at this time because she's going to have a hearing, at least one, maybe two. So she really is not focused right now on how much information you're going to need. Okay? At this time, the case will stand null pros, and then call her tomorrow or this afternoon, and then you can speak with her in depth.
So how would I go about getting it closed without having this become up
Now,
again?
the state makes that decision. Not me, not Ms. Tortorello, the state. So there's probably not a whole lot you can do. All I do say is don't do anything without talking to your attorney.
Yes, ma'am.
And please be mindful, you have bond conditions. Those bond conditions will end with the null pros, but don't do anything that might allow them to bring the case back is all I say.
Exactly. I don't do anything. That's why I wanted to get it all the way done over.
That's why I say talk to Ms. Tortorello.
No problem. Thank you.
All right, you're welcome.
Bye-bye.
All right. So Ms. Bing, ladies and gentlemen, the rest of the information. Ms. Bing is the solicitor on all of these cases. We have one solicitor. So she is speaking with people to try and address each case, but she is the only solicitor we have. Wait. Is Miss what is ASG King gonna help us out? Hello? I see another solicitor on. I didn't know if we were going to have some help, but essentially, Ms. Bing, all of these cases are hers. So I just need y'all to be patient. What does that mean? Keep your device muted so we don't hear anything that might be inappropriate or that you don't need us to hear. I will make announcements as often and as quickly as I can when I get information, and I will switch you out so that when Ms. Bing comes back and she makes an announcement, I'll switch her to the next person she needs to talk to. So just be mindful. I know there's officers on and everything. Be mindful that we're working with one solicitor and we're trying to move as efficiently as possible. Okay? All right. Thank you.
What's that? There's two motions going forward. What about them?
Your Honor,
Yes, ma'am.
I have two announcements. One is that, well, actually, they're both. Miss Lee and Mr. Barton.
Yes.
Well, Mr. Barton actually is going to be a plea, and Miss Lee, we're going to recommend DUI court for her client.
Okay,
so
hold on, because you give me the attorneys, but I only know
I'm
defendant.
sorry.
So Mr.
So for
Barton's
Fuller,
client is Fuller.
that's going to be a plea.
Okay.
And then for Terrence Raymond,
yes,
we're recommending DUI court. And I'm going to
Okay.
let that attorney, I think she wanted to say something. I don't know if she's back in the courtroom yet.
All right, Miss Reed.
She might be on her way.
She's on her way. Okay. All right, and then
is there anyone else I can get a conference with?
Yes, Attorney Scott Smith.
Yes.
Oh, okay, great.
Oh, Mr. Smith, are you replacing Miss
Yes.
Agramante?
I am. She had another Zoom, Judge, and we're all
Okay, no
standing in for
problem.
Miss Francis. She had a funeral to attend.
Okay, so I'm going to put you in a breakout room with Miss Bing. Miss Bing, when Miss Reed comes back in, then I'll confirm, and then we'll get a time for how long we're gonna put this out until we get a status update.
Okay, sounds good.
All right, and I'll confirm that with you. Anyone here on the calendar, please make sure you have your first and last name on the screen. Business is done with last names, people. So if you just have a nickname or one name, it's not going to help me. All right, Mr. Smith, I'm going to put you in a breakout room with Miss Bing. And once you, yes.
We also have Miss Janvier here who's offered to help to speed things along.
All right, so did you want to start the hearing on Compton and then Ms. Janvier talk to Mr. Smith?
Oh, that's fine, Your Honor. And then also, whenever you're ready for the plea for Ms. Fuller, I'll be taking that one as well with Mr. Barton.
Oh, okay. So let's go ahead and Ms. Bing, then while we do Ms. Fuller's plea, you go ahead and talk to Mr. Smith.
Okay, sounds good.
All right. So breakout number one
And,
is going to be Ms. Bing. Thanks, Ms. Janvier. Ms. Bing is, oh, Lordy, I think I put you in already. And Mr. Smith, 1 second. All righty. Number one. All right. So, Ms. Fuller.
Yes.
Come on up for the plea.
Thank you.
Mr. Lynch, did you have an announcement? Because you're at the camera.
No, Judge, I just wanted to make sure that the court knew. I believe Ms. Reed, that other attorneys that just came back in the courtroom. So I just wanted to make sure.
Okay, so as soon as we take this plea, Ms. Reed, we'll go ahead and confirm the DUI court and give you some instructions about what the next steps are. Mr. Barton.
Right, Judge, I've got Ms. Fuller here. Do you want her standing right here with me in the screen?
Yeah, that's fine. As long as she can be heard and seen, that's fine. So Ms. Fuller, raise your right hand for me. You solemnly swear or affirm, y'all gonna have to unmute the courtroom for me. You solemnly swear or affirm any testimony you give in this matter will be true. Speak up a little bit for me. Oh, y'all are muted. There you go. Speak up. All right. Ms. Fuller, Kaylin Fuller, you're before the court on 2019 CR 10371 for driving under the influence counts 1, 2, and 3, driving on a suspended or revoked license count 4, impeding traffic count 5, improper lane change count 6, open container count 7, and giving a false name, address, or date of birth counts 8 and 9. Mr. Barton, what is your client plead to the offenses before the court on 2019 CR 10371? Mr. Barton?
Yes, I did not hear you. I'm sorry.
I said, what is your client plead to the offenses 1 through 9 on that case?
Judge, we're pleading to an amended accusation. I'm not sure the count number. I'd have to defer to the state on that. And we're pleading to suspended license nolo. So we're guilty to a reckless and nolo to a suspended license.
Are we adding that as number 10?
No, I'm gonna update it, Your Honor. I'm doing it right now. So count one will be the reckless.
Okay.
Mhm.
All right, and then suspended licenses count 4.
Yes, ma'am.
And then we're dismissing counts 2, 3, 5, 6, 7, 8, and 9.
Yes, ma'am.
That's correct, Your Honor.
All right, Ms. Fuller, by entering a plea of guilty to counts 1 and 4, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf to not incriminate yourself. And if you are not a United States citizen, a plea of guilty or no contest could negatively status. Do you understand all of these things? All right, factual basis recommendation, please.
Judge will
Yes.
No, I want to hear them.
Yes, Your Honor. On July 9th of 2019, while an officer was on patrol of Fairview Road, where the incident occurred in Clayton County, the officer observed the defendant operating a motor vehicle traveling in the left lane of a 4-lane roadway, traveling at a speed of about 35 miles per hour in a 45-mile-per-hour zone. The officer also observed that the defendant had trouble staying in the lane and was drifting from side to side. The officer initiated a traffic stop, made contact with the defendant. As she didn't stop initially, the first thing the officer asked is, why didn't she stop? When he attempted to pull her over, said she didn't know she was being pulled over. At that time, the defendant provided a license and name of Rena, Renia, Donaldson, with a birthday of 7/20/1959, which was not the correct name and address for the defendant. The officer asked the defendant to exit the vehicle, and the officer observed that the defendant had an odor of alcohol coming from her breath. Noticed that her eyes were glassy and red. Asked if she had consumed any alcohol on that day. She advised that she had consumed 2 22-ounce beers of Coors Light. The officer asked if she would submit to standardized field sobriety exams, of which the defendant did agree and performed poorly. The officer then read the defendant the implied consent, in which she did agree initially and then withdrew her consent. And the officer then got a warrant for a blood search. The blood alcohol content was 0.02. However, the toxicology report also yielded that the defendant had was positive for cocaine.
All right.
The state is recommending for count 1, 12 months probation for the defendant to take a risk reduction course, a drug and alcohol evaluation, and any follow-up treatment. Have no drugs or alcohol and be subject to random screenings or testing. The defendants to attend 2 victim impact panels, at least 1 AA or NA meeting per week. Pay a fine of $1,000 and complete 80 hours of community service. Count 4 is 12 months probation to run consecutive to count 1. For the defendant to pay a fine of $500, continue attending at least 1 AA or NA meeting per week. The defendant is not to have any drugs or alcohol and be subject to random screens or testing. And to continue follow whatever the recommended treatment is. The defense has provided proof that the defendant has already completed a risk reduction course as well as the drug and alcohol evaluation. So that has been submitted. That's pretty valid.
Yeah, I left that
And-
with you. man.
Yep, you want it back?
I guess I need to make sure she gets it to probation.
Mr.
Okay.
Compton, I can hear you. All right. Mr. Barton?
Yeah, I'll swing back down and pick up the proof of DUI school and her evaluation and treatment. And I'll make sure she gets that to probation.
All right, so Ms. Fuller, I'm going to accept your plea of guilty to the reckless 12 months probation, a risk reduction course, substance abuse evaluation, and any treatment that was ordered. No alcohol or illicit drugs during the course of your probation. You're subject to random screens for alcohol and drugs. You're to take 2 victim impact panels, and you submit that information to the probation officer upon completion. You're to have 1 community support meeting per week. That can be AA, NA, or any meeting designed for the cessation of substance abuse, alcohol, or drug use. A $1,000 fine with the surcharges, that should be 1,420. 80 hours of community service. You're to have on count 4, 12 months to run consecutive to count 1. $500 fine, which will be $737.50 with the surcharges. 1 community support meeting will continue from count 1. No alcohol or illicit drugs during the course of the second 12 months. You're subject to random screens. You will continue any other special conditions that have not been completed during the first 12 months, including payment of any fines and fees and completion of any community service. Ms. Fuller, when we have issues, and I tell people this all the time, it's just like when you have diabetes or high blood pressure. If you don't take the opportunity to treat those things, they will kill you. Unfortunately, with substance abuse, if you fail to treat substance abuse, not only will it kill you, but the possibility exists that it will kill other people. So please be mindful of that. Embrace the fact that you have this disease and then do everything possible to remain sober. Okay? When you leave the courtroom, you're going to sign up for probation. You're going to go next door to courtroom 305. Ms. Nalband is in courtroom 305 within the first set of double doors. You're going to sign up with her. Any difficulties that you have completing any of the special conditions, discuss that with your probation officer, and they will help you work through anything. Any questions that you have about your particular situation and how it would affect probation, ask those questions of Ms. Nalband. But I promise you, if you fail to report to probation as directed, you will be rearrested. Do you understand? We understand each other? So we will be in a relationship for the next 24 months. We're clear?
Yes, ma'am.
All right. Now, I root for people to do well. And anybody who's come before me in probation who has an addiction issue, they know I'm hard on them, but I will root for you to do well. So maintain what you've been doing. Stay in your support meetings. Contact your sponsor if you have any difficulties, and try and maintain your sobriety to the best of your ability. The holidays are coming up. And I know this is a particularly difficult time for people for 2 reasons. 1, because of the presence of alcohol and drugs with people celebrating. But 2, because a lot of times the holidays bring up issues that are really at the core of what causes your addiction. Be mindful of this. And when it starts to get to the point where you may be challenged, be proactive, not reactive. We clear? All right. You can go on and get signed up with Ms. Nalband, and then you're free to go after that.
All right. Judge, thank you so much. That's all I have today.
All right. Thanks, Mr. Barton. Take care.
Very good to see you. Y'all have a great Christmas.
Good to see you too. All right. So my understanding is Belk was a withdrawal, Butts is a no pros, Compton is a hearing, Fuller was a plea. Grant was moved to the next available calendar in February. Holmes is a reset. Hubbard is consent. Keith is a plea. Lloyd, Murphy, Nash are withdrawn. Raymond is a recommendation to DUI court. Ms. Reed, my understanding is he needs to go ahead and today, if possible, complete his application for DUI court. We will set up a status hearing sometime in January to determine whether DUI court has accepted him. You can come to that by video. And if they have not accepted him, then he will be back on my calendar for either a motions hearing or to go forward with trial.
Okay. May I go back to the solicitor's office and get a paper copy of the DUI court application?
Did we have the DUI court application in the courtroom? I'm not sure who has that.
Oh, I'm sorry. I sent her a soft copy already in her email.
Oh, okay. You should have it in your email. So if you have to have him come in to print it out, that's fine. What was it? Is Mr. Murphy on in court or on video? Is it Murphy? No, I'm sorry. Is Mr. Raymond in court or on video?
He's here, Your Honor. He's in courtroom.
Mr. Raymond, come on up. Mr. Raymond, this is an opportunity to get your life right. Because if you're going to DUI court, that means that you didn't learn the first time, that you have a subsequent DUI. And because you have that subsequent DUI, that means that not only did you put yourself and other people at risk one time, you did it multiple times. And so what I want to express to you is the holidays are coming up. And you will have those people who get in your ear and say, man, you know, it's not that big a deal. She won't catch you just this one time. Just have a little taste before you go back to court, you know, and things get tough and they start making sure you can't drink. So let me just be real clear with you. You don't want to do that. You don't want to listen to those friends because those are not friends. You don't want to put somebody else's life in danger. You don't want to put your own life in danger. But let me emphasize to you, no matter how much time in jail or prison I ever gave you, if you end up killing somebody through DUI, you would wake up every morning knowing you took somebody's life. And there's no punishment that beats that. Wake up thinking about the fact that every time you open your eyes, you took somebody's life through your inability to use common sense and to make good choices. There is no punishment that would be worse than that. Got it this way too, sir. Usually it's the other person that dies and the DUI person lives, but it actually could be you. You could be the one taken out. The reason I say this is because this time of year, not too long ago, I had a gentleman who was out on bond for DUI, and he didn't listen to me when I said, don't repeat this behavior. And he went out and killed a 19 or 20-year-old lady who was coming from work on her way to do Christmas shopping. He hit her at 85 miles per hour, never once braked, slammed straight into her car. The computer on his car told us how fast he was going. He got a broken leg. She died. Don't do that to somebody. No. We got too much. We got Lyft and Uber, and we got ride shares, stuff that when I was your age, we didn't have that. But people are willing to spend all this money and do all this risk when they can spend $35 and do what they want to do. But that tells me you have an addiction. Anytime you got more than one DUI, you have an addiction issue. Because if it wasn't painful enough for the first one, that tells me you got an addiction issue and you need to address it. You understand?
Yes.
Don't let nobody convince you, oh man, ain't nothing wrong with you. Don't let nobody get in your ear with that foolishness.
I'm already in recovery. I don't think I'll pick up another drink.
All right. Well, DUI court will be the place for you because they are very, very, very supportive of people who are in recovery and are determined to stay in recovery. So go ahead and get that application done as soon as you can. Things slow down during the holidays, so we don't want to let it sit in somebody's inbox while they're on vacation. Go ahead and get that done as quickly as you can for Ms. Reed, and she'll submit that information, and then you will hear from the DUI court about whether you've been accepted. Okay?
Yes, ma'am.
All right. Thank you, Ms. Reed.
Thank you, Army.
All right. All right. So the last thing we have is Compton. We're having a hearing. We ready?
Yeah, Your Honor.
Yes.
I'm the registered nurse that drew Mr. Terrence's blood.
Yes.
Am I dismissed?
Anybody else need this gentleman?
No, Your Honor.
All right. You're free to go, sir. Thank you.
Thank you. Bye-bye.
All
And
right.
Judge,
Take care.
we did have that motion to modify bond conditions on my case. I'm sorry.
Okay. What are we trying to do?
Just modified to provide for contact.
Which case is this?
Yep. This is on Terry Holmes, and he's online.
All right. Do we want to put a statement on the record?
Yes, we do.
All right,
Ms. Boyd.
All right, Ms. Boyd, raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true. You got to unmute for me.
Yes.
All right, you can put your hand down. All right, so Ms. Boyd Holmes, you're under oath. Ms. Bing, go ahead.
Yes. Ms. Boyd, can you just state and spell your name for the record, please?
Marissa, Marissa, Boyd, Boyd.
Okay.
HOLMES.
Sorry about that. And what is your relationship to this case?
I am his wife, Terry Holmes' wife. That's my husband.
Okay, and you were the victim of a battery?
Yes.
Okay. Do you currently have any safety concerns?
No.
What would you like the court to know?
That I'm 33 weeks pregnant and I'm very high risk. And we have a 4-year-old too as well. So we have to, we have kids together. We have to contact each other. And I had a pulmonary embolism, so I need someone at the house with me just in case I go into labor. None of my family members are able to be here with me 24/7.
Okay. Did you ever speak to a victim's advocate in our office?
Yes, I did.
Did you mention that you would like to see your husband in some community support, like AA meetings, or do some anger management?
Yes, I did mention that.
Okay.
Yes.
Is that still something that you wish to see happen?
Yes, I would like to.
Okay.
But I
All right.
would still like contact with him.
Yes.
In
Yes, of course.
Like while he's still here at the home.
Of course. Okay.
Because the baby is due January 31st.
Oh, okay. Okay.
Mr. Holmes is at the house with you right now, isn't he, Mrs. Holmes?
No, he's not. He's at his brother's house.
Okay.
We haven't had no contact, no.
Okay. The concern that I have in these cases is your need is born more of your health conditions than any real a possibility that this won't happen again. This is my issue. And I get that. I've been in a high-risk pregnancy. I've known what it means to be scared and to need somebody to be there with you. So I get that. But what concerns me is your need to have Mr. Holmes is not born of the fact that this won't happen again. It's more a factor of the fact of you have a high-risk pregnancy, you have health conditions, and you need him to help you with the 4-year-old and the 33 weeks. So this is what I'm going to do. The modification that allows Mr. Holmes to come back to the home will require him to go to one community support meeting per week for the cessation of alcohol or illegal substances, and he'll also have to take an anger management class, which if he takes the anger management class, does not mean that he won't also have to take a family violence intervention program should he be convicted or take a plea. But in order to go back home, he's going to have to take an anger management class, and he's also going to have to attend one AA community support meeting per week. I don't care how you do it, whether by video or in person. And he needs to sign up with probation to go ahead so that they can monitor that.
Okay.
Mr. Holmes, I'm sorry, Mr. Holmes, you stay silent. Ms. Smith, Mr. Smith.
Thank you, Judge. We have no qualms with that. I'll be the gatekeeper if the court's comfortable with that as an officer of the court. I'll have him do the anger violence evaluation by tomorrow. I'll have it done. I've got a great evaluator who's state certified. And then as far as the AA meetings, I'll assist him in directing him to the AA website that has the locations for the different group meetings. And we'll get him to.
He needs to keep a record of it and not miss a week.
He will. And he's diversion eligible. That's where we're headed with this. It's just Miss Francis is out. So we were unable to get it done right now. Yeah, I mean, I'm comfortable with everything the court is asking, and I'm comfortable with her request as well.
All right. So now, children make life harder for a couple that's not doing well. The reason is because the focus is not on the two of you, the focus is on the little people. And if both of y'all are not pulling in the same direction and rowing the boat down the same stream, everything's going to be a mess. Everybody has to pitch in when there's a baby and there's a toddler in the house. There's no woman's work versus man's work, none of that foolishness. It is the work has to be done. People have to be fed, bodies have to be washed, kids have to be put to bed. All of those things have to be done. And it doesn't matter who does them, because the importance is not you, him. The importance is the fact that y'all are making babies. And if y'all keep making babies, that's the focus. So, because a lot of times those are the source of the issues. Folk aren't helping, folk feel stressed. There are issues that come with that. So if y'all are gonna be in relationship and you want your relationship to be successful, if you're gonna have no violent or harassing contact, then you may consider going to, I'm not ordering this, but I am ordering other stuff. But if you may consider, once the baby is here, going to counseling. Because if this happened one time, it can happen again. Don't fool yourself just because this happened and he's over and we made up and everybody's smiling in each other's face and there's a baby coming. Because I can't tell you how many times I hear, I want him back in the house because we're having a baby. That only makes you more vulnerable, not less. And so it concerns me. I feel like with the proper safeguards, this could work. But y'all don't be confused by the fact that this is in any means resolved. This is a stopgap. Okay. All right, Mr. Smith, if you'll submit that order, I'm going to put you in a breakout room with Ms. Nalband, who is the probation expert. Mr. Holmes. I'm sorry, Mr. Smith, you said you want to monitor and send in the information?
Yeah, I'll do it, Judge. No problem.
All right. So, Mr. Holmes, that means if you miss a week of your community support meetings, if you don't do the anger management, then they could, the state could ask to revoke your bond, which means that you would be back in jail and you would be there until such time as your case is resolved. Are we clear? All right, so those are the consequences. All right, we'll await the order from Mr. Smith. You're free to go.
They're going to teach me how to submit the order, Judge.
You can give it to Miss Kiara Powell, but you have to send it to Miss Bing. So you can put Miss Kiara.Powell at Clayton County, you know the rest. Put her on the email also with the email to Miss Bing so that Miss Bing or Miss John VA can review it.
Okay.
And,
all right. Get this out right now.
Thank you.
Thank you, Judge.
All right, y'all are free to go.
Have a good holiday.
Thank you.
Your Honor, can I have a conference with Ms. Tortorello before
Ms.
we start the
Tortorello?
hearing?
Ms. Tortorello?
Yes, Your Honor.
All right. Am I putting y'all in a breakout room?
Yes.
All right, so this is on Compton, which is the last case. Ms. Bing, Ms. Tortorello, breakout room number 1, I think. Yes, breakout room number 1.
Okay.
Second. All right.
Thank you, Your Honor.
You're welcome.
Your Honor.
Yes, ma'am.
Okay, we're ready. We're just gonna stipulate to the video coming in.
Okay.
Yes, Your Honor, and I need to call my client. I don't know if he got kicked out or if he decided to log out, but if give me 1 second. I see him. I see him.
Ooh. All right. Let's see. Mr. Compton. Mr. Compton, I'm gonna need you to see your video, please. Mr. Compton, start your video.
I think he just came back on, Your Honor. Not sure if he's having technical difficulty. He's calling me right now. Give me a second. He's logging back on, Your Honor. I'm not sure what's going on with his phone. There he is, Your Honor.
All right. This is the state of Georgia versus Damian Gerard Compton, 2021 CR 08201. Mr. Compton is before the court for too fast for conditions and DUI less safe. Ms. Tortorello is representing Mr. Compton from the law firm of Lichtenholt Dennis. The state is represented by Ms. Bing, Stephanie Bing with the solicitor's office. Ms. Bing, who are you calling?
I'm calling office.
Hold on, Ms. Tortorella. I know we're gonna have to I'm getting a witness list. That's all. So
Okay.
I know who I have to put into a breakout room.
Okay. I'm calling Officer Michelle Reed, she's gonna be my first witness.
Mm-hmm.
And then Trooper Marquavius. He's logging back in. Oh, Trooper Majors. There he is.
Majors.
Mm-hmm. I also may be calling Leonard Acure.
Okay. All right. Anybody else?
No, actually, I'm going to use Mr. Acure first and then Michelle Reed. So
okay. Well, I'm going to put them all in the breakout room so Ms. Tortorello can make her opening. So the rule of sequestration is in effect. Mr. Acure, I'm going to put you in breakout room number 3. Trooper Majors, breakout room number 3. I'll make an announcement when it's time to come out of the breakout room. And Officer Reed, breakout room number 3. Let's see. There we go. All right. Officer Reed, you got to join the breakout room. Just click on the invitation. She'll put you in.
And Your Honor, just for the record, I don't see Officer Reed on the state's witness list as on the discovery.
Okay. All right. Are you asking me for something?
No, just on the record.
Okay. All right, so all three are in the breakout room. Ms. Tortorella?
Excuse me, really fast. She actually goes by Benton, which is on the,
Oh, thank you.
yes, sorry,
Okay.
her last name is changed.
Okay.
Sorry.
Great, thank you. Okay, Your Honor, we are here to ask, Your Honor, to suppress all evidence of Mr. Damian Compton that was found after his vehicle was searched illegally during an inventory search. Evidence includes the empty bag that smelled of raw marijuana, HGN results, consent to the implied consent reading, and the blood test results provided by the GBI. Mr. Compton's vehicle was illegally searched by Trooper Majors of the Georgia State Patrol and used inventory search as an excuse to find evidence of contraband in Mr. Compton's vehicle. This is supported by State versus Lockinger, 357 Georgia App 852 2020. Furthermore, the trooper did not have probable cause to search the vehicle. This illegal search violated my client's constitutional rights under the Fourth Amendment. Therefore, because the search of Mr. Compton's vehicle was illegal, any evidence found within and any evidence obtained poisonous tree and should be suppressed. Moreover, Mr. Compton's left leg was injured as a result of the car accident, and defense is asking this honorable court that the one-leg stand and walk and turn be inadmissible due to unfair prejudice under OCGA 24-4-403, Rule 403. The tests were performed despite Trooper Majors knowing that Mr. Compton sustained injuries to the left side of his head and leg. And this is supported by State versus Chambers 921 SE 2D 496 2025. Nothing further.
All right. State?
Yes. Harris v. State 307 Georgia App 847 lists examples of impaired driving, which includes the officer's own observations, a conclusion that he's left safe to drive, and a traffic violation. What you'll hear is that the defendant blew through a red light, hit an on-duty officer who was patrolling the area, impacted other cars in the intersection, and landed in a tree and had to be towed out. For inventory searches, Martison v. State states that when a car is impounded, that they are free to do an inventory search. There was also the detection of raw marijuana, which the officer notes on camera, giving him more indication that there was something else afoot, and then conducted a DUI investigation. Therefore, the state's going to prove that the blood, that the search was lawful. There was plenty of probable cause, and the fields that were conducted during the DUI investigation were also lawful.
All right. Call your first witness.
Yes, I'm calling Leonard Acure.
All right.
I think he was on, and
that's okay. They're all in the breakout room. I'll call them out.
Oh, that's right.
All right. Mr. Cure, you can leave the breakout room at this time. Your testimony is requested. All right, Mr. Acure, you can leave the breakout room. Your testimony is requested. Activate your screen to leave the breakout room and return to the main room. 1 second, let me see. Maybe he's not hearing me. Mr. Acure, your testimony is needed. You can leave the breakout room by activating your screen and returning to the main room.
I might be able to contact Ms. Janvier so that she can get him. I'm not sure where. Oh.
Here he is. It
Oh,
takes a
okay.
minute.
Okay.
All right. So, Mr. Acure, raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true.
Yes, I do.
All right. You can put your hand down. Ms. Bing.
Okay. Acure, can you state your name and spell it, please?
It is Leonard Ekure, Leonard. Last name is spelled Ekure.
And where do you currently work?
I currently work for the Clayton County Solicitor General's office as an investigator.
Okay. Describe a bit of your past work before you were an investigator.
Yes, a brief description was I was a police officer for a little over 14 years here in the Clayton County Police Department. My duties consisted of traffic enforcement training, responding to 911's accident reconstruction, and a particular skill set in drug recognition as a trained drug recognition expert and instructor.
Okay, and tell us a little bit about drug recognition experts. What exactly does that mean?
Okay, recognition expert is a rigorous training program where the officer or the student is put through a 7-day, 140-hour class to identify the 7 major drug categories, the effects of those drugs on the human body and how that affects the everyday driving or affects normal driving. As a drug recognition expert, it is important to be able to identify what specific drug is affecting the body and make an accurate call. Training consists of a classroom portion. You take 19 exams in 7 days, and a proficiency part where, in my case, I was flown out to the Maricopa County Jail in Arizona to do field certifications, where I had to test unknown drugs out of inmates who were in that particular establishment at a level of competency, which I did.
How long have you been a drug recognition expert?
I've been a drug recognition expert since 2015.
Okay. So is that 10 years?
Yes, ma'am. About
Okay.
10 years.
Okay. Were you post-certified?
Yes, I am.
Oh, you are now, and you were then as well?
Yes, that is correct.
And so just roughly how many DUIs investigations have you conducted, just roughly in your experience?
Personally involved with probably a little over 2,000.
Okay. And more specifically, DUI drugs.
DUI drugs, so maybe a couple hundred, 300 maybe.
Okay. All right. Can you speak a little bit to maybe the differences between what you might see, if there are any, differences you might see in a suspect that is pulled over for DUI drugs versus DUI alcohol? So let's say when you're conducting a test, a field sobriety, or you're first making contact, what kinds of things you might see in a suspect that's under the influence of a narcotic versus alcohol?
Okay, so that question is very broad, but I'll specify alcohol specifically with a stimulant, and then maybe cannabis, marijuana. Would that be?
Your Honor, objection. As far as I understand, that the state has is submitting Investigator Curia is an expert for this. But unless he's testifying to the actual investigation itself, I believe I object to any testimony regarding this matter unless he was actually there. I believe it's supported by one of Rule 702. So I would object to that unless he was at the scene and he actually observed my client. I would object to any testimony.
Yes. So he's not saying that he was there. He's not testifying to anything that he saw of Mr. Compton. He's simply speaking of his expertise as a DRE that can give us a foundation for what the officer who was there might have seen, because there is a lot of, I think, confluence between symptoms of alcohol and symptoms of marijuana. And so it's simply informational. We're not at all speaking to the incident.
I think if we were in front of a jury, that would be fine because you would need an expert to explain that. But we're in front of me, and I have to make the determination about whether there was probable cause for an evidentiary probable cause for.
Your Honor, we can't hear you.
Yeah.
I'm reading. Probable cause for the search due to it being an evidentiary search for a car that was impounded. And also whether any information from that search can be used or whether it needs to be suppressed. That's number one. Number two, whether injury to the leg and injury to the head made the field sobriety exercises inadmissible. So those are the two things. I don't know that I need a drug recognition expert. You may want to save that for trial.
Okay. Can I do this? Let me just ask him one question that I do think is relevant, and it does come up in the report, and I think goes to the point of
All right, go ahead.
Well, it's okay.
Your Honor, I would like to just say something else. We didn't get any notice, and I understand he's one of their expert witnesses here. I understand the rules require for defense to actually get notice if they're going to call an expert witness, and we did not obtain any such notice.
All right. Ms. Tortorella, I just said I don't really need them. So sustain.
Thank you, Your Honor.
All right.
No problem. Thank
Do
you.
we have another witness?
Yes. Miss Reed, Officer Reed.
Okay.
Mr. Curia, thank you for your time. You can log off.
Okay. Officer Reed, your testimony is being requested. Officer Reed, your testimony is being requested. You can exit the breakout room. Officer Reed, your testimony is being requested. You can exit the breakout room. Investigator Henderson, can you send her a text message that she can come out of the breakout room?
Yes, Your Honor.
Thank you.
Oh, I see her. She's here now.
All right. Cool. I didn't think it would take that long. But Officer Reed, raise your right hand for me. You got to turn your video on for me.
I have it on.
It's just showing your name. There you are. Raise your right hand for me.
Okay, there.
You solemnly swear or affirm any testimony you give in this matter will be true.
I do.
All right, you can put your hand down. Your witness, Ms. Bean.
Okay, could you state your name for the record and spell it?
Michelle
Officer Reed?
Reed. Michell. Can you hear me?
Yeah, sorry, it was a bit spotty. Could you say that again?
Michelle Reed. MICHELLEREED.
Okay, and can you tell us what you do?
I am a supervision officer for the state of Georgia.
Okay, and with what department?
The Department of Community Supervision.
Oh, sorry. Okay, were you with any other agencies maybe a few years ago?
No, I was still with the Department of Community Supervision. I was working in Clayton County.
Okay. And can you just describe some of your duties?
I supervise individuals that are under sentence for parole and for probation for the state of Georgia.
Okay. And how long have you been doing that?
For over 20 years.
Is that kind of position a post-certified position?
Yes, ma'am, it is.
It is. And are you post-certified?
I am.
Okay. And were you post-certified in 2021?
I was. And I was during that time.
Okay. Were you on duty on May 30th, 2021?
I was.
Okay. And can you just describe what you were doing?
On May 30th, 2021?
Yes.
During that time, I was driving a Dodge Charger. It is an unmarked unit, but it is a state vehicle. We are in uniform. I was leaving one of my supervisee's residence, going to another supervisee's residence. We check them in their residence in the community to make sure that they are compliant in a favorable manner with their court order. And that's what I was doing on that Sunday morning.
Okay. And did anything, sorry, were you on 85 South and Georgia Highway 138 that day?
I was going on 138, turning left on State Road 85.
Okay. Is that in Clayton County?
Yes, ma'am, that is.
Okay. And did anything of note happen?
Yes,
at that
ma'am.
juncture?
I was in the turning lane. It's a double turning lane. I was in the far turning lane. There was another vehicle that was on the left of me. The light turned green for us to turn, and I proceeded to turn. I turned out first, and before I could stop, to my left, the vehicle blew through the light, struck me on the driver's side. And when they hit me and kept going, they ran into one of the poles that are on the right-hand side of 85, State Road 85. That would actually stopped him, and some bushes and another sign. It's a kind of brick kind of sign that that's there in Clayton County. My car, I proceeded to coast onto the side of the road. Traffic stopped at that intersection. I got out of the car. I proceeded to call and let someone know that there has been an accident. I didn't know if it was a medical emergency or anything of that sort. So I got out of the car, walked over to the car, when I approached the car, you could smell marijuana out of the car. But I did ask the young man, was he okay? He said that he was okay. And then he proceeded to ask me, was the light red or was it green? And I just told him, just stay in the car. We'll be with him shortly. A lot of people started getting out of their cars and started screaming and yelling and things of that sort. I just asked them to get back in their cars and things of that sort. At that time, Riverdale had approached the scene. And by the time I got to my car, my knee had gave out at that time. And then EMS got there. And I was told to go ahead and just take a seat, take a knee, pretty much, because my knee and my ankle and my back was injured in regards to this accident. So at that time, the other agencies took over, and I just told them what I just told you.
Were there any other, you mentioned that there were people that were getting out of their cars. Were they hit? Were they scattered? How were they impacted?
No, they were pretty much angry. I remember one of the statements about the young man running through the light and
Objection,
hitting.
hearsay.
No, it wouldn't be hearsay because I was there. That's what they were saying.
Yeah, objection, hearsay.
Sustained.
You can describe, don't say what someone said.
There
but
were
just
angry statements towards the young man. That's the reason why I was asking them to get back in the car.
Gotcha. Okay. Who did you let know that there was an accident? What did you contact Riverdale, or Riverdale just came?
I called 911. I called my supervisor at the time, and they filtered everything out.
Okay.
I use the state phone, so all of that information, it circulates.
Okay. All right. Was there anything else of note about the defendant that you, well, let me ask you this. Do you see the person that hit you on this platform?
I can go through and see if I see him.
Sure.
If he can move his cap, I can make it more visual. I can't properly identify. Can you get a little bit closer? Yes, that looks like him, Mr.
Okay. Was there anything that you noticed about his appearance, his affect, anything of note?
Just as he looked a little in disarray, and that kind of thing. And he didn't know that the light was red or green. And that was evidenced by the question he asked me. He didn't know if it was red or green.
Okay. Okay. No further questions.
Cross-examination.
Good afternoon, Officer Reed. How are you?
I'm okay. How are you?
Good, thank you, ma'am. So, you mentioned that you walked over to the car. You testified that you walked over to the car and you could smell marijuana out of the car. Is that right?
As I approached it, you could smell it on the exterior of the car.
However, you didn't tell that to Trooper Majors, did you?
No, because I was with EMS at that time.
In fact, you told him when he came over to it, because you are, let me get this, clarify this. You were you were the victim of the car accident, correct?
I was.
Okay. So when Trooper Majors arrived at the scene, the first thing he did was interview Mr. Damian Compton. Isn't that right?
I couldn't tell you that, ma'am.
Okay.
I was with EMS at the time, so I couldn't tell you that.
Okay. Eventually, he made it to you, correct?
Yes, ma'am.
Okay. And you were interviewed by your vehicle on the day in question, correct?
Correct.
And you were interviewed at State Road 138, and the cross intersection would be Highway 85. Isn't that right?
No, I was interviewed on State Road 85 on the off road on 85.
Your Honor, at this time, I am going to share my screen. And I'm going to ask Miss Officer Reed a couple more questions. So give me just a second. So you're stating that you were interviewed on Highway 85, correct? In Riverdale.
State Road 85.
Okay. And Officer Reed, when Trooper Majors questioned you, you told Trooper Majors that you had your mask on at the time. Isn't that right?
No, I didn't tell him I had a mask on.
And you told him that because you had your mask on, you couldn't smell marijuana coming out of the vehicle. Isn't that right?
No, that is not right. I didn't state that.
Your Honor, at this time, I'm going to play a portion of the video, and I'll let you know the time mark for the record in just a second. Let me get to the okay, here we are. And you're saying, officer, this is State Road 85 or Highway 138?
That's State Road 85.
Okay. So, Your Honor, I'm going to start playing the video at time mark 25 minutes and 18 seconds. Or, yeah, sorry. Actually, for the record, 24 minutes, 57 seconds.
They want to stop me, boy. All right.
Hello.
Hello.
How are you?
All right, I made it to you.
I appreciate it.
Obviously, you are vehicle number 2 today.
Yes, sir. Unfortunately.
Unfortunately. So
Please not put my.
I'm not.
Okay.
We don't do that.
Something happened.
Really? I'm sorry about that. We'll run it, but then other than that, we'll put you with that?
Department of,
Correct. Community service, supervision.
yes.
Yes. Gotcha. I'll put their address. What's their phone number?
77.
Your dispatch over there.
The main number is 770.
Okay.
960 4100. My state contact is 404-558-1172.
This is that reason why I be paranoid going through the intersections.
What?
That's not here, but
The other that she was on the
was she behind you?
no, she was on the side of me.
Okay.
And I was in the second lane turning.
Okay. You was in second turn lane. Coming from 138?
On to 85.
So that'll be the one to the right?
Yeah.
You know what I'm saying? The turn lane.
Yeah, right.
So how you miss her? Oh, she wasn't paying attention. She admitted, that's right. She admitted that she wasn't paying attention, but so she was just like,
Yeah.
I just so happened to look back up.
I just went ahead
Yeah,
and.
you was going, yeah, okay. That makes sense, man. So you went through the light for her. Man, that's crazy.
And normally it's like, normally I drive real slow,
Right.
you know, like grandma slow.
Right.
And today I just went ahead and just go with traffic.
Yeah, that's gracious. Are you hurt? I saw you limping. Your left knee?
Yeah.
The next half, Cleveland Avenue, a black Crown Vic, black Ford Crown Vic, Robert Paul Williams, 7652, RPK 7652.
He asked you that? Oh, wow.
Yes, sir.
My question is, what was he doing? And I may investigate a little bit, see if he was upstairs.
She had on the red and white, she said that she was partially on marijuana. But I had my mask on, I didn't smell it, and I would have.
For the record, Your Honor, I'm stopping the video at 27 minutes and 55 seconds.
Okay.
So, again, Officer Reed, it was your testimony that you said that you smelled marijuana coming out of Mr. Compton's vehicle, correct?
Yes.
However, in the video, that wasn't your testimony that wasn't your statement to Trooper Majors, isn't that right?
I can't hear that part. It said that I had my mask on, but I didn't hear the part about I did not smell it.
We can repeat that then for the record.
Okay.
I didn't hear it either. If you can turn it up, that would be helpful.
Okay, at 27 minutes and 16 seconds, and I'm gonna see if I can turn up the. It's on max, so I'll play it again.
Robert Paul Williams, 7652, RPK 7652.
He asked you that? Oh, wow.
Yeah, that's what Riverdale
Yes, sir.
said. Like, you gotta have, like, green, definitely don't know.
My question is, what was he doing? And I may investigate a little bit, see if he was upstairs.
She had on the red and white, and she said that she was partially on marijuana. But I had my mask on, I didn't smell it. I went over there. As soon as I went over there, they told me to go get my license, and then they wouldn't let me back because when
I'm stopping at 27 minutes, 59 seconds.
I asked, can you continue it a little bit further to see what else did I say?
I
After
only need
that?
the video to be played at that time. So isn't that what you said to Trooper Majors? That
when I approached?
That you had your mask on and you didn't smell the marijuana. Isn't that right?
It appears that I did, but I wanted to hear what else that I said in regards to that.
Sure.
Gotcha. Okay.
is he okay though?
Yeah, he's fine. He's standing up and everything.
Are you serious? Did he say what?
And now, but I guarantee you, speed was a factor, though. He did. What's that?
Stopping the video at 28 minutes and 44 seconds. So you mentioned, you just testified that Mr. Compton asked you whether the light was red or green, correct?
Yes.
You remember when 9:15 you're downstairs. This one is double ended, but they
Sorry,
playing on one end and
Investigator, here, if you can mute yourself.
to the front
Okay, so, and you would agree with me that your car was totaled in the accident, correct?
The state car, yes.
And you would also agree with me that Mr. Compton's car was also totaled in the accident, right?
I can't confirm or deny that, ma'am.
Okay. And that's fine, but it was a hard hit. Would you agree with me?
It was.
Okay.
Because I was injured in that accident.
Okay. And wouldn't you agree with me that somebody coming out of a hard, like a very serious car accident, like what you experienced, could come out of the car disoriented and injured, like yourself?
I can't confirm or deny in regards to that, unless you want me to speculate.
I'll be asking the questions, Officer Reed. So, in your personal knowledge, though, you were in a car accident, correct?
I was.
So, would you agree with me that you were a little disoriented after the hit?
As a mental, no.
Not mental, just disoriented.
I would say no. Not as in, no, I wouldn't say that part.
Did your airbag?
As in what I'm understanding you, you don't want me to ask you any questions, so I'm trying to get clarity.
Right,
so I wouldn't say as in that part.
That's fine. If you need clarity, let me know. Okay.
No, I wouldn't say no. I wouldn't say that. No,
okay.
Not to that degree. No.
Nothing further from defense, Your Honor.
Redirect.
Yes. Ms. Reed, it appeared, I heard clearly, it says, I had my mask on. Now, I couldn't tell whether you said I couldn't smell it or I could smell it, but, and I can replay it if you need me to, if you want to hear it again, I'm not sure, but it was your testimony that you said, well, that you kind of went along with what Ms. Tortorello suggested. My question is, what was the it? Because we could not hear everything around that remark was inaudible. Can you recall whether or not, what the it was? Did he ask you about alcohol? Did he ask you about marijuana specifically?
They were talking about marijuana because
objection, hearsay.
She asked what the question was. You just played the video where they asked the question. Overruled.
Go ahead, Ms. Reed.
They were talking about the marijuana.
Okay. Are you certain that you heard or said that you couldn't smell it or that you could smell it?
What I remember was that I stated that I smelled it. That's what I remember.
Okay. All right. No further questions.
Recross?
None, Your Honor.
All right. May this witness be released or is she being reserved?
I'm gonna reserve for a rebuttal just in case.
All right. If you'll activate your screen, Officer Reed, if you can go back into the breakout room, and then are we calling the next witness, Trooper Majors?
Yes, ma'am.
All righty. Trooper Majors, you are able to come out of the breakout room at this time. Your testimony is required. If you can come out of the breakout room. Thank you. All right, he's back. All right, and Officer Reed, if you just activate your screen, you should be able to go back into the breakout room. All right, Trooper Majors, raise your right hand. Wait, I can't see you. There you are. Okay, you're gonna have to pull over, sir.
I don't
I gotta pull over.
I don't have the breakout room.
Okay, hold on. I'll put you in a breakout room again. No
Thank
problem.
you.
Spot.
Atlanta to 76040. Atlanta to 76040, 10-4.
Oh, 10-4, thank you.
All right, you should see the invitation. Officer Reed. All right, she's in the breakout room. Trooper Majors, are you stopped?
I'm sitting in a turn lane at the moment, Judge. I'm trying
All
to
right, let me know
there.
when your vehicle is stationary.
Okay, I got about 30 more seconds. I'll be able to pull over.
Okay.
What?
Okay.
All right, thank you, sir. Raise your right hand for me.
We are stationary.
I'm sorry.
What was your secondary?
Raise your right hand. Do you solemnly swear or affirm any testimony you give in this matter will be true? Trooper Majors, can you hear me?
I do.
Do you solemnly swear or affirm any testimony you give in this matter will be true?
Yes, ma'am.
All right. Your witness, Ms. Bing.
Yes, hello, good morning, afternoon.
Morning.
Could you state your name and spell it for the record, please?
It's going to be Trooper Majors, Marquavius Majors, Marquvious. Last name Majors, Majors.
Okay. And can you, I know it seems obvious because you're a trooper, but can you just tell us what you do?
So I'm with the Georgia State Patrol out of Post 47, Forest Park. I investigate crashes, DUI enforcement, and enforce highway traffic law.
Okay. And are you post certified?
Yes.
Okay. How long have you been with that department?
I've been with the Georgia State Patrol for an estimate of 8 years now.
8 years. Okay. How many DUI investigations have you done in those 8 years?
I would say I've had several cases.
Several meaning 3, more than 3, 10, more than 10?
I would been 25 at this point.
Okay. Sorry, I don't understand. Okay. Are you able to hear me?
Yes, I am.
Okay. Okay. Were you on duty on May 30th, 2021?
Yes, I was.
Okay. Do you recall an incident on Highway 85 and 138?
Correct.
Okay. Can you tell me what brought you there?
So I'll be frank, it was a bit distant in time, but I familiarized myself with it. This was due to an agency assist call in reference to Clayton County units requesting assistance on DUI and crash investigation. There was an individual named Damien. He was driving the vehicle, traveling on Highway 85. It was my understanding that there was a police vehicle that was entering the intersection at the time. Mr. Damien ran the red light, and he made contact with the police vehicle. After he made contact with it, his vehicle ran off the roadway, which would be considered the southwest end of the roadway. So he lost control of the vehicle and ran off the road. That being said, after I made contact with Mr. Damien, I suspected that he was perhaps under the influence of something.
What gave you that suspicion?
Well, one, I couldn't smell alcohol, but I could definitely smell marijuana off his person. Um, when that was introduced to me, I took inventory of the vehicle because that's something we normally do when we investigate crashes. Um, I could smell, excuse me, I could smell unburnt marijuana inside the vehicle. The vehicle had a plastic bag in it, and the marijuana was there was no context. It was more so like shakedown. In layman terms, it's basically like very, very small leafy objects inside the bag. So either it was thrown out or consumed. As more cases, sometimes it gets consumed when there's an investigation about. Um, anyways, long story short, uh, I could smell the marijuana off of Damien's person, and then I began to do. I want to do fields on him. At first, he was very hesitant about it, but when I asked him further questioning, he advised that he would actually do it. Uh, but this was up until the point where he perceived that he was about to be under arrest for being under the influence. Once he agreed to doing the fields, I asked to see his tongue. It was brown, it was patchy, it was raised. So they gave me the indication that perhaps it was either he had already smoked some of it or he had consumed some of it. I could also see some of the leafy material on his tongue. So with the odor emitted inside the vehicle and coming off his person and seeing actual marijuana substance on his tongue, it was, to me, it was quite evident that uh, that he was perhaps under the influence of it. Um, After I finished the crash investigation, it was concluded that he did run the light. Um, he said that he was doing about 40 miles an hour. Based off my previous crash investigation experience and training and crash reconstruction, um, I gave an estimate that he did 60 plus miles an hour upon impact. Um, that being said, I felt as though his judgment was altered and perhaps delayed when he came up towards the intersection.
When you took inventory, well, was a tow truck called?
A tow truck was called. Now, this tow truck may have been released through Clayton County. Let me, if you don't mind, if I.
Well, it's okay. That's not
Okay.
important. Just
Okay.
you do
Okay.
recall that there was a tow truck, right?
Correct. Correct.
Okay. And was the vehicle impounded?
Yes.
Okay. When you search the vehicle, well, let me ask you this. When you search the vehicle, beyond the plastic bag, was there anything else that you recall finding in there? Any other marijuana related contrabands?
To the best of my knowledge at this current moment, there may have been something else, but it's just so distant in my mind right now.
I'm going to share my screen and play a portion. Give me 1 second.
Mr. Compton, this is your hearing. You may want to sit down somewhere and be present. Pretend you're actually in a courtroom. Ms. Bing, what we doing?
Sorry, it was easier for me to
Okay,
pull
so
it up
Ms.
on my.
Bing, are you admitting the video? Is it, are you
Well,
presenting for identification?
we stipulated to the video.
Okay, all right.
All right, so let me share my screen. All right, and y'all can see that?
Yes.
Yes.
Yes. Okay. Can y'all hear that?
No, I can't hear.
Not yet.
Can't hear anything? Okay. Okay. Run now.
Yes.
Definitely smokes marijuana. So many Swisher Sweet packages. With the guts of the, I'm not gonna say guts. Swisher Sweets with the contents of the cigar taken out of the actual cigar. So what are you putting in there if you're not smoking inside your car? If you're not smoking marijuana? I got a bag that smells like raw marijuana. And a scale. Okay.
So I'm going to ask the question again. Do you recall what else you might have found in terms of contraband or marijuana related items in the car?
Yes, it was drug paraphernalia. So when I searched the vehicle, a scale was found. Besides the bag, Swisher Sweets is a cigar brand that is used commonly for smoking marijuana. Basically, they take the wrapping, they take the contents outside the cigar, and they replace it with the marijuana substance, and then they rewrap it. That being said, those contents were missing. And considering that the bag that actually smelled like raw, unburnt marijuana, that told me that perhaps that Mr. Compton has already smoked it or he was preparing to smoke it. And perhaps he consumed the marijuana, prior to impact.
Okay. Did you conduct fields on Mr. Compton?
I did. And the odd thing about that is when I conducted the fields, I did observe clues on him.
I'm sorry, you said
Which
you did or did not?
I did. I did.
Okay.
So I was able to.
What clues did you observe?
Go
Sorry.
ahead.
What clues did you observe?
I observed lack of smooth pursuit, distinct sustained nystagmus at maximum deviation, and onset nystagmus prior to 45 degrees in both eyes. So I could see nystagmus in his eyes. Now, traditional marijuana does not show HGN, but with certain laced synthetic series of marijuana, these drugs are they're susceptible to showing nystagmus because of the substance that's inside of it. So not only not only was that a indication that something was in his system, a narcotic can show nystagmus or HGN, which is horizontal gaze nystagmus. So when a narcotic is mixed with marijuana, the HGN is present. Because that led me to my investigation that he was still under the influence of a narcotic.
Okay. Okay. That's fine. I think that concludes my questions.
Cross-examination.
Good afternoon, Trooper Majors. How are you?
How you doing, Swell? Thank you.
Good. At this time, I'm gonna be playing your dash cam.
Okay.
Okay. So I'm gonna share my screen. 1 second. I'm gonna start it at the stop, okay?
Okay.
Okay. For the record, I'm starting the video at 9 minutes and 5 seconds.
Okay.
There's no sound. I don't know if you intended it that way.
Can you hear it?
Nope.
No? Okay. I might have to.
You have to share your computer sound when you share the screen.
The audio is on. Okay, hold on a second. Let me try something else. All right, I'm gonna start at 9 minutes and 16 seconds. And let me know if you can hear it now, because
Yes.
yes?
Yes.
Yes.
Yeah. Go ahead.
Trooper Majors, what's going on with your volume at this point?
Not quite sure. Is this the body mic or
That's dash.
dash camera? What's supposed to happen is it's supposed to switch over to the body mic. Sometimes when it gets released, sometimes the body mic does not transfer. Is it not how's it being played? Is it just the
It's
actual
just
camera?
not capturing your conversation with Sergeant Ortega of the Riverdale Police Department.
Okay. Let's see. Not sure about that one. Sometimes when the mic isn't pulled and if it's in the cradle, it doesn't activate the body mic until, honestly, I mount it and then step out the car. But the in-car should still capture something.
Did you just turn your mic on there?
Yeah, I would say so. I would say so. The body mic activated.
Okay. So you just sit with him. Okay. Mr. Compton, how you feeling? Yeah. All right, then check out.
Okay, I'm not hearing much. I'm just hearing sounds, but I'm not hearing content.
All right. Then what happened?
Your Honor, is your volume on max?
Yeah.
Go. Okay. You spun out or?
Can you hear it now?
Yes.
Which way you coming? You coming from this way? You coming south, right? Okay. Yeah. And she come from turn lane going this way? Okay. Right. I got you. And you, what lane were you in? So were you in the far left lane? Where? All right, so you got two lanes right here. Besides the turn lane. Were you in that lane or this lane? In the middle? So this one. This one. What this black truck is using that lane. That truck, look at that truck. You see that truck? All right, lane. Okay. Did you hit anything? I mean, like, did you hit anything inside the car? Okay. All right. Let me talk to her real quick, and then I'll be back over here. All right. Okay, so you got witness phone number? Yeah. All right. All right. I hope you already got him. Okay. Well, hold on to that real quick. Got you. On is up police officer. Yeah. Got you. They already got the car in the middle. I wanted to my okay, good. Okay. Yeah. Let me put it on the CAD real quick. You're not here. I'm gonna take pictures.
Sorry. 5766.
10-4.
4
Your Honor, I'm not sure what is meant to be shown or proven through this.
I don't know what's going on. Ms. Tortorello, are we getting somewhere?
Yes, Your Honor, I'm trying to play the video from the moment the officer arrived all the way up to arrest, so Your Honor sees a full picture before I go ahead and cross Trooper Majors. Because you will see evidence will show.
Okay, you don't have to tell me all that. Just tell me, I just need to know what we're doing technically, because I'm just sitting here.
Yes, Your Honor.
Sure, I'm sorry. Yes, 116, my badge number, I'm sorry, 150. Okay, okay, gotcha. Write the officer's name, and then write the witness. Telephone number. Yeah, bye-bye. There's 8, 418, 999. On my page.
Your Honor, I'm gonna fast forward a time mark at 22 minutes.
Okay.
That's okay?
Yeah, her information real quick, I let her go.
Actually,
05.
at 23 minutes, 32 seconds.
How's it going, sir? All right. All right. Good to meet you, man. You too, you too. All right. State car. Yeah. This is the independent witness. Okay. Sergeant King, I want to make sure I talk to him. Get everything. For yourself. Let me get her information real quick. I'll let her go. How you doing? All right. All right, so you're a witness today. All right, so just get a phone number. First initial. Last name. SW. That's it. Yeah. It's been a long day. I know we got started since 6 o'clock this morning though. But so, you saw what happened, right? What happened? Right. I'll tell the truth. I ain't gonna tell no story. All right, so swear to God, you tell the truth. Yeah. By then, she had all started to pull out. The turn light was green. Right. He came barreling through the light, and he hit her. When he hit her, his car turned, and he was going backwards compared to 5 feet. The turn is staying up on the tree. Okay, that makes sense. That's lining up. That's the same thing I heard as well, even with a off-duty officer saying it. So, appreciate that. So, yeah. Oh yeah. Might be. 38 line track for one. Yeah, he might be. He might be. Checked on her first. Yeah. She kept saying, so how was his mannerisms when you first saw him? He was just thinking that because other people were talking. Was he staring off in his face? Yeah. Okay. Okay. He climbed out the car. Yeah, climbed out the car on his own. All right. Well, like I said, I'm gonna let you go. I know I ain't gonna hold you no longer here. I promise some chicken. If we can give you some chicken, we can give you some chicken. I was just on the way to Popeye. Yeah. Well, you be safe, okay? All right. I'm just glad he didn't get I would have been a customer. Get my dog on. No, that's right. That's a nice car too. You be safe though. Probably I ain't gonna get hit. Yeah. Hold what you got. Hold what you got. Stop. Don't pull out. Uh-huh. They want to stop me, boy. All right.
Hello.
Hello.
How are you?
All right. I made it to you.
I appreciate it.
Obviously, you are vehicle number 2 today.
Yes, sir. Unfortunately.
Unfortunately. So.
Please not put my.
I'm not.
Okay.
We don't do that.
Something happened.
Really? I'm sorry about that. We'll run it, but then other than that, we'll put you with us?
Department of
Correct. Community service. Supervision.
Yes.
Yes. Gotcha. I'll put their address. What's their phone number?
770.
Your dispatch or whatever.
The main number is 770 960 4100. My state contact is 404 558 1172.
This is that reason why I be paranoid going through the intersections. What's down here? But
that thing was on the
was she behind you?
no, she was on the side of me.
Okay.
And I was in second lane turning.
Okay. So you was in second turn lane. Coming from 138?
On to 85.
So that'll be the one to the right?
Yeah.
You know what I'm saying? The turn lane.
Yes, right.
So how you missed her? Oh, she wasn't paying attention. She admitted that's right. She admitted that she wasn't paying attention, but so she was just like, I just so happy to look back there.
I just went ahead and
Yeah, you was going, yeah. Okay. That makes sense, huh? So you went through the light for her. Man, that's crazy.
And normally it was like I drive real slow,
Right.
you know, like grandma slow.
Right.
Your Honor, I'm sorry. Is it absolutely necessary that we watch? This video is almost 2 hours long.
And she wanted to play it until the arrest, so.
Your left knee?
The next path, Cleveland Avenue, a black Crown Vic, black Ford Crown Vic, Robert Paul Williams, 7652, RP 7652.
He asked you that? Oh, wow.
Yes, sir.
My question is, what was he doing? And I'm gonna investigate a little bit, see if he was updated.
Is the interview with the second vehicle necessary to rewatch?
If ASGB, if you could, please, stop talking over the video. I think it is necessary as there were questions as to what she said, whether or not she said.
But this has been belabored, so I'm raising a
Hey,
relevance
hold
issue.
hold on. Miss Tortorella, the sound quality hasn't improved, so I don't know how replaying it is gonna help me. I got my sound up to max. So unless you got a way to make it better, because what I also get is there's overtalk from the microphone in the car on some portions of it.
I
So
just
whether
think it's important because if I skip, your honor's not gonna get a full picture of when he first did, because he did, you're gonna see 2 inventory searches of his vehicle.
okay, well, just
So,
go on, but like I'm saying, this part I already got, so.
okay.
She gave her information, she's talking to him. But at the point where you asking about the marijuana and all of that, not only was it almost unintelligible because of the sound, but it also had some crosstalk during portions of it.
Yes, your honor. Let me get to where he goes back to where Mr. Compton was, as this was already seen. I'm playing the video at 35 minutes and 50 seconds.
Yes, sir. Okay. And I wrote this right here, that really because I hear on the light. Okay. The last vehicle going through the intersection. Okay. LT over there got had a witness too, and she said the same thing. Yeah. So, I mean, I have more about check. Yeah, I mean, 3 witnesses. Yeah, more than you. I got to answer this year. Can I give you a ticket, thank you? Sir, can I give you a ticket computer? Oh, yeah, that's our ticket. No, that. In your hand. Oh, no. What you saying? What's it? Oh, this is our state phone. It looks like a brick. That's what I want to use. That's when you lose that thing. Yeah, we take pictures, you take pictures with it, you can send them. And I think it looks like a connection that you put in the computer too. Pretty cool, man. And it's a geo tracker too, so they can track you with this. You got like, yeah. How long you been in,
Your honor, I'm gonna fast forward to 38 minutes. Time mark. Right there. 37 minutes, 54 seconds.
Yeah. Oh, I think that one of the females on your class, she put a skirt to you, didn't it? I don't know. White female? I know just not much. She was on the Nighthawks. Okay. Yeah, she was on Nighthawks. Hey, you go ahead whenever you're ready. Okay. I'm about to take pictures of it. I want to get enough views so I can take a picture. Yeah, I probably will. If I can find something. Inside the car. Inside the car, it's not me the bag. Yeah. It smells fresh. And, okay. And he's strong. Okay. When I was to another office, yeah, I do everybody from it right here. Yeah, I'll because I was gonna do it. I was gonna do SFSP on it. He looked low. Yeah. And he can't remember what lane he was in. That's one. The lane, nor he And then when I went over there, they said that he couldn't even remember, he asked the officer was the light green. Yeah, from the light that he was traveling on. How you gonna ask the officer that you hit from another, opposite direction, was his light green? It's on the ground. I'll take a look at it though. Please now, thank you for let's say if I keep on doing it. No. You know, same thing I'm doing. He took the sign with him? Hey, drag it out for me. Yeah, you bastard. I ain't much we can go from here right now, man. I bet you in the tight or something. Yeah. All right. Let me ask you something. What's this? You have trouble remembering if the light was green or not? Was it green on yours? The witness said it was green too? Okay. All three of them said the light was green? That's strange. Which one? Which one? Yeah. If he was over here? Yeah, did she tell you which direction though? So they all told me they were recording body cam, so. Yeah. That they were, to have the officer, you know, they have the green light to turn, you were the last person coming through. And then I was right. They might have been something to you, oh, they told me, okay, they were, all of a sudden, they're being recorded. So this gets to court, they're gonna have to be in my video. So Trooper has my case number too. With that being said, on the back end of that, you're yeah, I know you're looking at it, but it's no. Let me take this picture. Wow. That's that rim popping that curve twice at the same time. Right. That was moving, ain't it? Now you like this on the road. When you hit the curve, you carried a lot of speed, man. I never seen that before. When you spun out, your back end is basically that rim is rubbing against the pavement right before you hit the curb. After you hit her, you spun around, and that wheel is gouging on the pavement. How fast were you going? 40? That's hard to believe with a 40. If you was going 40 miles an hour and you hit that patrol car, you would have stopped right there in the intersection. That could have been a 40, man. Hey, I'll tell you this. I'm calling the ball. That's at least 65. At least. Gonna train that. You know what? 3 come 1, 2, 3. Yeah. That's about. All right. Commissioner Smith. Originally, I was doing inventory, but then back when her car reeks of marijuana. You must have just dropped it off. You just dropped it off? Come on, man. Hey, you know about this bag? Sorry. Oh, that's another fight. Oh no.
338, line of training, one word.
You smoke marijuana? You don't smoke? Did you smoke while you was driving, man? No. Come on, don't lie to me now. You did not smoke. How often do you smoke marijuana? Couple days. Every couple days? When's the last time you smoked? Yeah, when's the last time? Well, right over in that. Very simple. You like it? Good.
Your Honor, at this time, I'm gonna fast forward to 1 hour and 4 minutes where the FSD start, the field sobriety testing starts.
The clothes. Did she drive up? You drove up here? You did? Yeah, you gonna take them out then. Yeah, that's the guy. He's at the other one. That guy's on the phone with it. Oh. I'm about to do SFSD on him. Field sobriety. For the sake of this, you know, you're not really saying if he's going to, we don't know if he's going to. It's just better to put the motion, especially with, you know, you could either really matter on. So you've been up front with you. No, you hate it. I'm gonna just make sure he's good prior to drive. So. What's in this bag right here? You got a clip bag in there? Your clothes? Oh, the same day they had it up. This. These are your clothes? If you had spread that on there. Yeah. Oh. Saw your papers. Would you rap something? Oh, okay. Man, like a hustle, I guess. Oh, that's your yeah. Oh boy. Got a lot of stuff, man. All right, you can just take the stuff out, put it right down on the curb, and then I'm gonna go through field sobriety with you. Go through field sobriety. Field sobriety. We move to that. Standardized field sobriety. Standardized field sobriety. Okay. Make sure you use good prior to driving. All right, let's go and let you stuff out. Oh, you need the keys? Okay. You gotta do that? Do what? Do what now? The field sobriety? Okay. He just denied field sobriety. Yeah, you go ahead and close it up. So what happened now? Okay. Did you deny it? But you say I ain't gotta do it though. You asking me or are you telling me? I can't give you these advice, man. All right, so from here, sir. Okay, you're being detained. All right. Understand. From my perspective, it certainly sounds like you said I ain't gotta do that. But you're on the phone with your mom. I don't hear that. Okay. But when I said something about field sobriety, I let you put your thing down, and you come back to me and you say I ain't got to do that. No. So are you asking me? Do you want to do field sobriety or do you do not want to do field sobriety? Field sobriety is on this is prior to making sure you were safe to drive prior to this crash. Okay? You gotta understand from my perspective. You're a regular marijuana smoker. You're traveling at a speed that's obviously way fast on this roadway. Okay? I want to say the speed is right here 45. You're traveling over 45. Okay? So you're over the speed limit. You ran a red light. Property damage. I mean, that's kind of like at that point, it's a must to do field sobriety. Okay? So you understand that. Now, you have the obligation to refuse. Do you understand that? So are you gonna do field sobriety with the field? Or are you not gonna do field sobriety? Yes? Okay. All right. So I'm gonna uncuff you. I'm gonna allow you to do field sobriety. All right? Okay. Don't run over me. Okay? Let me do it.
Your Honor, I'm gonna fast forward to 1 hour and 11 minutes. It's almost there, actually. We're 1 hour, 10 minutes, 52 seconds.
All right, just gonna bring them over here. Hey, the far right corner, far front, my patrol vehicle. You injured? Your leg? So your leg hurt. All right, so let me ask you this. You had any head trauma? No? You hit your head? Is that side? Is it hurting or, I mean, it's hurting? What about, you got a problem standing on one leg? Okay. Do you think you can walk in a straight line or stand in one leg? Stand on one leg. Do you have a problem with that? You don't feel comfortable? You shake your head, so I'm asking. You do feel comfortable? Okay. All right. So what I want you to do is follow the tip of my finger, okay? With your eyes and your eyes only. No movements with your head, no body swaying, or anything like that. All right? Okay? Look straight at me. There you go, just like that. Cross your feet. Sure. All right, cross your feet. There you go. Just like that. All right. I continue to focus on my finger, all right? You consumed any alcohol today? Okay. Can you stand up? All right, so you see this line right here? All right, come over here. Right there. Take your right foot. I'm sorry. Take your left foot, place it alongside the line, so don't step on the crack, okay? You got it. So right, just like that. Now take your right foot, place it in front of your left foot, touching heel to toe, just like that. No, take your right foot, place it in front of your left foot, touching heel to toe. You got your left foot in front of your right foot. Take your right foot, there you go. Just like that. Hands right side at all times. Okay? All right. What you're gonna do, you're gonna take 9 heel to toe steps from where you're standing alongside this line, and on your lead foot, you're gonna pivot, turn back around, take 9 heel to toe steps back. Make sure that your feet are touching heel to toe. Okay? I'll demonstrate. I'll take 3. 1, 2, 3. Lead foot, pivot, turn back around. 1, 2, 3. I took 3, you're gonna take 9. Okay? You understand the instructions? All right. All right, you may begin. All right, good. Okay. All right. All right, turn back around this. Well, you know what? That's good. Come right here. All right. Now, you already said the left leg hurts, so I'm not giving you a choice, but I'm just saying. You're gonna choose either leg. You're gonna stand on that leg with your foot raised approximately 6 inches off the ground, like so. Gonna keep your hands by your side. You're gonna count out loud 1001, 1002, 1003 until I tell you to stop. Okay. You understand the instructions? All right. So I'll give you the benefit of doubt here, y'all. You know, you say you live it, so you practice best. You know? All right, you may begin.
Point west, capital S, point west, capital S, built for Hyundai, Tucson.
All right.
3NA6541, Charles 46541.
All right, come on, back this way for me.
Charles Nora Adam 3541, CNA 6541, Georgia. Okay. That's it, sir. Thank you. That's it, sir. Usually, it's like for a two vehicles, not like Henry. 766.
Your Honor, at this time, I'm going to fast forward to 1 hour, 25 minutes and 16 seconds.
What's left to show me, Ms. Tortorella?
Some of the results of well, officer expressing, a trooper expressing to the other officer about results.
I don't care about that.
Okay.
You're not asking me about the results. You're asking me about whether they should have been done, correct?
Well, it has to do with.
Okay, let me just tell y'all, I've seen enough. The inventory search was done properly, incident to the car being disabled and being towed. So anything recovered from due to the inventory search is fine. It's not illegal. The second thing is the FSE should have never been done because he had a head injury and a leg injury. He had nystagmus, could have been a part of the injury that he received to the left side of his head. He indicated that he had an injury to his head. And at that point, nystagmus should have been, the nystagmus test should have never been done. And with respect to his legs, he got up and was limping. He was unsteady on his feet. And to perform FSEs, first he said no, and then we kept talking to him until he said yes. And at some point, I believe I heard, because of the poor audio quality, that he was in cuffs prior to being told to do the FSEs. And so that was improper. So the FSEs will be suppressed. The HGN, as well as the walk and turn and the one leg stand, the inventory will not be suppressed because it was done properly, incident to a car that was inoperable, that was going to be towed anyway. All right, ladies and gentlemen, thank you all so much.
Thank you, Your Honor.
All right, take care.
You too.